Supplemental list item number 37 for judgment. WPC 3131 of 2022.
The instant restitution therefore stands restrict save and accept the observations made in paragraph 14 and 15. 14 and 15 is regarding there is some expenditure incurred. So let them go and file civil suit.
Highly obliged, sir.
Mention for listing a motion matter on Monday.
Right?
It's the eviction matter.
Do it today.
Today, my lord, some typing is needed, my lord.
No, you have not filed it.
We filed it, my lord.
How can you pay? You have
You-
typing is
that we
required.
will rectify it, my lord. The
Huh?
public will to be listed on Monday.
Sorry. No. You have not filed it, I am not.
Already filed, my lord. For some.
Can't be, you say that your typing is
No,
there.
some typing is there, by this time it will be completed.
You make a mention on unlisted on Monday. For what?
Panchayat law conference.
This is Surana not sitting today? Okay. It is for?
It's from law conference information.
Do it
Press
today.
matter, my lord. Press matter.
Today.
Today, my lord. Highly obliged.
May it please, your lordship. Your lordship, I'd like to mention a new writ petition which I filed yesterday. The matter is relating to a risk and cost tender which is being floated by the MES, wherein after cancellation of my contract with the MES, they were supposed to value the plant and machinery left by me at the site as per the registered valuer. But they have not done so. They simply took quotations from my contemporary contractors, and they obviously quoted a very less rate of around 10 lakh rupees, whereas the machinery goes to around 70, 80 lakh odd rupees. And now in that risk and cost tender, they stated that whoever wins that particular bid, they will get those plant and machineries. So I'm highly aggrieved by that non-following of the MES manual, wherein they've specifically stated that it has to be valued by registered. Monday, your lord. Highly obliged.
Withdrawal. Today. Monday.
May I please, your lordship, I have to mention for listing of case, my lord, on Monday, my lord.
Monday.
Monday,
For what?
for auction sale, my lord, for motion, my lord.
Is the matter?
My lord, regarding the sale of property in auction, my lord.
You make it mention on Monday. Make a mention on Monday. Huh? Sorry, yes. Then? When do you want it? Mr. Council, I can't understand what head or tail you are saying. Kindly explain it clearly. Why do you want it? You want it today or Monday? Tuesday. Oh, mention it before the regular bench. Next. You mention it before the regular bench on Monday. Yes.
Daily list item number 1 for motion.
I'll did you. Yes. See your mic, something is wrong? You try. Yes, tell me. Yes, you raise your voice. Yes.
Case of the prisoner is done, Lordship. Is it company, Lordship? Immediately after getting the amount also we will including the interest will pay the amount. But some time with the also in the meantime also 40 lakh will be. That may be lost. And we have also capital retention, also devising all things that we are ready to pay thus after immediately after getting the money.
Their claim is 6 crores,
3 crores 39.
3 crores.
No, it actually it will be for 4 crores or 38
Okay,
lakhs.
4 crores, 38 lakhs is there. You say that, and is that 4 crores taken into account after taking into account the 60 lakhs?
Mal-
No, that has not been.
No,
deducted
that
from
has been,
Huh?
that has been adjusted.
Okay. Anyways, you pay how much? 50?
15 lakhs.
We have it after 15 days. We stay it, it is 50 lakhs.
My lord, actually, my lord, what
We
happened, my
will
lord?
consider on that day.
40 right as it's second and
55?
My lord, just I'm drawing your lordship attention to page 22, my lord, annexure A2, my lord. Area, my lord.
Annexure?
Page 22. Annexure A2.
Yes.
This is a area, my lord. This is a period, my lord. This is from 1/4/2020. Then, my lord. This against this area, my lord. 50% is the already PF contribution collected from the employees, my lord, at the time of making payment of their salary. That amount also they have not deposited. It is out of this total amount.
No, Mr. Das, we will take note of that.
My lord.
Let them first pay this 50 lakhs.
Well,
And then on the next date,
Well.
you take your instruction how much. And what is the state of affairs as regards the land acquisition?
My lord.
What is the state of, what is the status of the land acquisition proceeding?
already they have NOC lordship to it and they are already not in final position.
Huh?
Final step.
What is this final stage business? No, what has happened out there in the land acquisition?
We have given NOC, the payment has not been made
NOC for what?
for lordship acquiring the our land.
Has the land notifications been issued by the acquisition authorities?
But probably it is final.
What is this probably? There's no probably business out here.
I have
You get your instructions. We'll take it up at 12.
regarding lordship that land acquired.
Land, what is the status of the land acquisition and this 15, today is what date?
It is 28, my lord.
28. So you have to pay by next is, by 14th, by 14th of August, you have to pay this 50 lakhs. Take your instruction. We'll take it up at 12.
My lord.
Barton.
I number 2.
Before your lordship, my lord, is the, my lord, the chairman of a society. But I am agreed by the order, my lord, at page 41. Here it
Been submitted by Swanko regarding illegality. Formed by the chairman and secretary in preparation. Yes,
now, my lord,
against that, whether an appeal lies.
my lord, a review lies, my lord. I have preferred a review on the very next page, page 40. As per section 111 of the statute.
Then
Then, my lord, the review is pending, my lord. And my contention before your lordship is that, my lord, that the lordship has seen that order, my lord. This order was passed on a petition filed by one Deva Gustave. That complaint petition was not furnished, number one. Secondly, my lordship had seen that, my lord, an enquiry report. That enquiry report is not also furnished.
you have taken those grounds, I taking.
Yes, I have taken, my lord.
Then what do you want?
Now, my lord, the case, my lord, my case is that, my lord, this voter list was engrossed by this honorable high. The lordship turns to page 16 for a while.
Page?
16.
Yes.
My lord, this is the order, my lord, where the election was not held due to the voter list. Now, lordship may turn to.
When was the election held?
Election held, my lord, 4 years back, my lord. It is, my lord,
No. Election now held. When was the election held?
election was held on, my lord, 17/3/2009.
So the voters list does not change for last 5 years.
It is up to them. Now that they have said, my lord, that election was held in an invalid voter.
Which one? 18
The election, yes, the election which I won,
in 2018.
2019. 2019, yes. If your lordship sees, my lord,
Yeah,
page
some property.
page 17, my lord, last paragraph.
Okay, then
My lord, last paragraph, for a once, my lord, page 17, last paragraph.
Hmm.
Once the voter list has been finalized, after giving due notice to the shareholders, the question of reopening the matter once again based on the complaint subsequently received from the shareholder leading to the postponement of the AGM election does not appear to be a correct course of action. So, my lord, the court, my lord, the honorable court directed to held the election. But some of the persons, my lord, who are not arrived in the writ petition, they preferred a writ appeal, my lord. The very next page, my lord, page 19 is the writ appeal.
Hmm.
Now, in the writ appeal, my lord, lordship may turn to page 26. My lord. Page 26, second paragraph. In the light when the election process has been set in motion, and in that view, the Lahmi single judge was of the opinion that the process is to complete in accordance with law, and a direction was issued to complete the process within a time.
but the division bench did not interfere in view of the
Yes.
election being set on motion.
Yes.
Then-
Then. Now, my lord, the question is the voter list which was prepared and the voter list on which I contested and I won, my lord, that voter list was prepared not by me. It was prepared by the then one-man managing committee.
Mr. Dotto, I understand everything, but I'm asking you what this court can do now when you have filed an appeal and the appeal is pending, appeal or review, whatever it.
My lord, my prayer will be, my lord,
Yeah.
my simple prayer will be that, my lord, till disposal of the, my lord, the review application, my lord,
Hmm.
this order may be suspended.
Huh?
This order, page 41 may be suspended till passing of the, my lord, passing of the finalization of the review application.
Whether there is no power.
There is no power. And in fact, my lord, that complaint and the inquiry.
Except
report is
really-
submitted to me.
The review is filed before whom?
Before the person who has passed the order, with the
With
raised.
the raised hand.
order.
You may review any order passed by him at any time within 60 days from the date of publication. except the subsequent. An appellate authority and the register in a case of review may pass any stay order pending any appeal. Then,
No, nothing has been passed.
no, then why have you not approached them? Why should this court at all interfere?
My lord,
Yes, my lord.
my lord, my point is, my case is that, my lord, the complaint and my lord, the inquiry.
You file an application before that.
I have filed an application.
No, where?
My lord, that
Where is the application for stay?
Not stay, my lord.
Then-
I have filed an application, your lordship will see, my lord, at page 42, my.
Yeah.
42 is the, my lord, prayer for review of the order.
Yes, you have only asked for prayer of the review.
Yes.
Then where is the stay? Under 11.4. Then what do you want? Dismiss? Withdraw? Which one?
My lord, has-
Either of it.
my lord,
My lord, may I submit
Can
one thing, my lord?
Huh?
I think that the one order passed by a court.
No.
This is, my lord, the order, my lord, there, my lord, it was asked to, my lord, to provide the complaint, my lord, as well as the inquiry report.
So you have already asked that. Have you not asked in your application?
Even that, my lord, neither they have.
Why are you not filing an application for stay? Once that stay is rejected or not granted, if any prejudice is caused, then you can very well approach this court.
It was filed on 17th. Day, my lord, 27th, my lord.
But where have you asked for stay? If you have not asked for stay, why should this court, when the statutory authority competent have already, you have exercised the review, why should this court to do?
My prayer was before them, my lord, to review the order.
Then they will.
My lord, and to withdraw the order.
Withdraw is final.
My lord.
Then where is the stay? Why haven't you asked for stay?
I
For
only-
what?
my lord, only prayer, my lord, before the limited prayer, my lord, till disposal of the review, my lord, can it be stated?
Mr. Counsel, no, nothing doing. So what do you want? Dismiss or withdraw? Either of it.
If you're not sure, otherwise.
No, leave it to me. The withdraw, you have to say. And if it is dismissed, then you can very well leave it to me.
My lord, in the
Or
case-
should we understand that when you leave it to me, I should dismiss it?
my lord, in that case, my lord, then the doctor pass an order both of the review application within a time frame. That may be after hearing. If it's providing the.
My lord,
The petitioner,
lord, the petitioner lordship is the different person in the affidavit lordship. The name of the petitioner reflected Rafiqul Islam in the petition. In the affidavit, it is Rafiquddin. It's not the same person, my lord. Page 13.
Rafiqul Islam,
In my petition is Rafiq.
they have now corrected in your thing. Rafiq, wait, the person, Rafiqul Islam. Okay, no problem. The instant writ petition has been filed challenging the order dated
13.
13/7/2023 passed by the Register of Cooperative Society Assam, whereby the said authority had dissolved the elected body in terms with Section 39 of the Assam Cooperative Societies Act 2007 and the Zonal Joint Register of Cooperative Society Guwahati was directed to appoint an officer on management to correct the voters list and convene the AGM/election of Bhattadhrava SS Limited within 90 days as per section 41(6) of the Act of 2007. It appears from the record that the petitioner herein, how many petition?
One minute.
The
The chairman.
petitioner herein, who was the chairman, who is the chairman of Bhattadhrava SS Limited, hereinafter for short referred to as the Cooperative Society, had prepared a review against the said order dated 13/7/2023 before the Register of the Cooperative Society in terms with Section 111 of the Act of 2007. From a perusal of the petition as well as the contention so forwarded by Mr. N.J. Dutta, the learned counsel appearing on behalf of the petitioner, it appears that the case of the petitioner is that the voters list on the basis of which the AGM/ the election was held on
10/3/2009.
10/3/2019 was already approved by this court in WPC number by an order dated 28/2/2018 passed in WPC number 1121/2018. And as such, it is the submission of the learned counsel for the petitioner that the Register of Cooperative Societies could not have held that the voters list was erroneous. It is the further contention of the petitioners that the Register of Cooperative Society have acted have passed the impugned order dated 13/7/2023 without taking into consideration that the petitioner herein, who was the chairman of the said cooperative society, was not served the complaint petition as well as the inquiry report So submitted by Sri Chandan Mishra, SRCS Morigaon. The Learned Council therefore submitted that the said order dated 13/7/2023 is on the face of it erroneous and requires interference. I've also heard Mr. N.D. Gogoi and M.D. Bora appearing on behalf of the Corporation Department, who submitted that when a statutory authority in terms with section 111 is already taking up the said issue on review, it may not be proper on the part of this court at this stage to interfere. First, upon hearing the counsels, the Learned Council for the petitioner, however, submitted that the said order dated 13/7/2023 has acted prejudicially to the interest of the cooperative society, taking into account that a one-man person have been appointed and a democratically elected person have been ousted on the basis of a proceedings initiated, an order passed without following the principles of natural justice. He further submitted that the said order dated 13/7/2023 may be stayed pending disposal of the review proceedings before the said court. It, however, appears that although the petitioner had filed a review on 17/7/2023, but the petitioner have not filed any application in terms with section 111(4), whereby a power has been conferred upon the Register of Cooperative Society Assam for the purpose of to stay any order so passed. The Learned Council, appearing on behalf of the petitioner, submitted that he may be permitted to file appropriate applications seeking stay before the Register of Cooperative Society, and further submitted that the matter requires an urgent disposal at the say review proceedings requires to be urgently disposed of by the Register of Cooperative Society, taking into account the inconvenience as well as the prejudice caused to the members of the cooperative society. Upon hearing the counsels, therefore, this court disposes of the instant writ petition, thereby not Next. Taking into account that a review proceedings is already pending before the Register of Cooperative Society, who has the power in terms with section 111 of the Act of 2017. It is the opinion of this court that interference with the order dated 13/7/2023 at this stage would not be in the interest of justice. The petitioner, it is the further opinion of this court that the petitioner can very well agitate the points so submitted before this court, before the Register of Cooperative Society. This court further is of the opinion that the petitioner can be well advised to file an application for stay of the said order pending disposal of the review proceedings. Inasmuch as the Register of the Cooperative Society has the power in terms with section 111(4) of the Act of 2017 to stay such orders so passed by the said authority. This court is also apart from the above, this court cannot also be unmindful of the fact that a democratically elected chairman, managing board of directors, na?
Yes, board of it.
Board of directors have been dissolved by the register of the cooperative society by the order dated 13/7/2023. And as such, it is the requirement that such review petition so filed requires to be disposed of at the earliest. In that view of the matter, the instant writ petition therefore stands disposed of on the following terms, as per the following directions and observations and directions. Number one, the petitioner herein, the Register of Cooperative Society, Assam, shall dispose of the said review proceedings at the earliest and not later than 30 days from the date a certified copy of the instant order is served upon the Register of Cooperative Society. Number two, the petitioner herein is given the liberty to file appropriate applications seeking stay of the order dated 13/7/2023, and the Register of Cooperative Society shall, taking into account the urgency zone, pass appropriate orders on the said application immediately thereupon. Next. Aru ki or se? Kuch- Anything else?
The one man property has not taken over the task.
That I'm not, you asked for stay, that is it. Anything else? This one?
I'm deeply obliged.
At the earliest,
Which one?
the stay application.
I said, not heard, I said immediately pass orders.
Task order.
After receipt of the application.
I have asked them to pass orders immediately on filing, not stay.
Deeply obliged, sir.
Full stop.
At number 3,
Sir, at a line likhna. The non-entertaining of the instant writ petition as regard the challenge made to the order dated 13/7/2023 shall not prejudice by this court, shall not prejudice the petitioner before the in the review proceedings pending before the Register of Cooperatives.
Obliged, sir.
3,
Yes.
He was supplying gas to the respondent of 2030.
itu, Abbas mana ni?
56.
Mr. Das, kindly no. Thank you. औरत कोई ठीक होती उतना टेबल की आवाज सुनाना पाएंगे आपको तो कौन नहीं क्यों? Yes, Mr.
Under the petitioner, he was supplying gas to the respondent of 2030. Now a new clause has been introduced. The NIT General Lordship would at date 26.
Why the impugn order dated issued by respondent number in favor of respondent number 5 shall not be set aside and what? Why the respondent shall not be directed to issue a fresh notice for hiring passes on contract basis to enable the petitioner and others to participate. Yes, now what is the
Page 26, Your Lordship, you can see
page
26.
26? Yes.
Fresh NIT has been issued from persons, travel agent, handling and carrying agent, registered as travel agent, registered as handling agent and carrying agent and registered under registration. Providing for 2 buses. Now, page 27, Mother.
It still are only invited from person to and so handling agent to and so registered as travel agent, registered as handling and carrying agent under the Registration Act for providing 2 buses on hire. Okay.
Now, page 27.
Hmm.
The bidder should be registered as travel agent, registered handling agent under the registration.
Hmm.
Respondent number, private respondent, he is not.
Huh?
He is not. Private respondent number 5, to whom the now the fresh order has been issued.
Hmm.
Now the second condition, your lordship, can you see? The vehicle is clause C. And the vehicle offered shall be registered in the state of Assam only as commercial vehicle and goods.
And commerce, only.
The vehicles that are proposed to be provided must not be older than 5 years. That is also, I have no problem because it is a new clause. I have no problem because that's why.
Are you challenging the tender conditions?
I'm saying whether the person doesn't have to pass.
Or respond number 5. Right.
He doesn't have to pass.
He does not have
He
a,
passed
first, he is not a registered
under the registration act
registration.
and.
Secondly, he does not have a,
His,
his vehicle is not registered in the state of Assam.
no, his vehicle is registered, but he has hired mass from private owner. And he has taken power of attorney and but he doesn't, the lordship committee, the F. The supplier must have at least one spared registered bus of similar capacity in his name in favor of his name against which he is submitting the bid. All the clause shows that a person must have pass of his own. So therefore, when the person doesn't, not having any pass taken off, but otherwise I could have also, hiring some passes from somebody, I could have also submitted.
He participated.
No, I could not participate because of the standard condition.
Then
Then respondent number 5, my lord, who doesn't have pass, my lord, on his own, my lord, he has been given the contract for. He, because he has hired pass from some other person. Third, that your lordship will kindly see page 35.
so you say that he does not comply with number F.
Yes. He doesn't have, and plus all the buses which he has offered, 2 buses which he has offered doesn't belong to him.
Is it required?
It is required because
Where is
he
it?
must have bus.
No, the supplier must have at least one spare registered bus of similar capacity in her name
That is one.
or in favor of his or her fame name against which he is submitting the bid.
That is spare bus.
Ah.
But other also, my lord.
Others doesn't say that he has to have his bus.
It doesn't, it goes to show, my lord, one must have their own bus.
Huh?
Otherwise, one must have their own bus that you can hire buses.
But it is not apparent, Mr. Das.
But otherwise also, my lord, it shows that one must have bus. But otherwise also, that spare bus one must have.
Hmm.
That is also not there.
Then
Then the qualifying experience, my lord, he qualifying experience of working in government department or any public sector undertaking, I think this is also not there. So your lordship will kindly see page 30.
who is appearing for the respondent? Your private respondent.
Lordship, I am not private respondent, Lordship.
Huh?
I am for Lordship the up to respondent number 4, Lordship.
For higher education.
Lordship.
He has given affidavit at page 34.
Who?
The respondent of private.
Yes.
I am a citizen of India, page 34. I am the registered authorized representative of the registered owner of the below mentioned vehicle. I'm maintaining the vehicle properly.
Description of the vehicles are mentioned below, registration number. That the vehicle is fitted with proper, I maintain, I am the registered authorized representative of the registered owner of the vehicle.
Representative of the vehicle owner. Then the power of attorney is given by law, page 36 of the 3 owners of the vehicle.
Hmm.
If this is the condition, my lord, they could have very well stipulated in the condition, then I could have also participated. I am supplying vehicles to them since 2013.
Hmm.
Even now, my term exists.
Yes, what is your stand?
Lordship's petitioner has not participated in tender process. If your earlier approach before the Honorable Court, my lord may kindly peruse page 22. Page 22, paragraph 3, Lordship.
Page 22.
Earlier round of litigation, Lordship,
Ah,
that he has challenged the tender condition of that party, tender clause 1 and clause 2B, Lordship.
Yes, what happened to his
And
representation?
on the basis of that, my lord, page 25 lordship. Page 25 lord.
Then, so you rejected that.
Lordship, that was rejected lordship.
Uh,
And lord-
Then,
here,
no, what, is it required to have his own bus or register?
lordship, as per the tender clause lordship, it is not reflected that lordship.
What do you say about F?
F lordship, it is a spared bus lordship. But the main condition is other. And that bus is lordship for transporting the students lordship.
No, understood, but transportation I
The
understand, but
lordship.
he has to have one spare
Lord-
bus of his own.
That part today I cannot say because lordship, the report is not before
Hmm.
us lordship. Other thing is there lordship, already tender is lordship awarded to the respondent of 5 lordship.
Hello?
And he has also not participated in the tender process due to this particular ground lordship, the bus is older than 5 years old. If this is the lordship may issue notice, I will place the report.
Okay. Now, Mr. Das, have you challenged that rejection of your communication?
Not challenged. That was
I'm
not
not
challenged.
there because
Now, if you not, that means you are not an eligible tender,
I have not participated.
but you couldn't have participated also.
That is not there.
Then why should this court
Now-
at your behest?
Now I find a lot, person who doesn't have any pass, they have been selected.
So what? No, no, understood. Whatever may be. But the question is, as of now, unless you challenge that decision by which your thing has been rejected, you don't become eligible.
I don't become eligible, but the way they have sent out-
Then it is a case of a PIL. Don't you think it's a case of a PIL?
I am affected because.
How are you affected? You cannot get it because all your buses are more than 3 years old.
I don't.
I would have said that you could have otherwise for other vehicles, this F, but you don't comply with D and E.
No, I do not, but he also doesn't have bus. He has hired the bus. That condition was given that one can hire bus. I can supply it. I
Lordship,
am supplying buses. to
one
taxis to
clause-
He's not a hiring bus. He's
Law-
taking on the power of attorney. He's doing it on behalf of somebody else.
clause D
Why
says-
haven't you done it?
Because this condition was not there.
Why is it mentioned that he has to have his own bus?
No, Lordship,
The
clause
same
D
thing
says
is
that
not-
Lordship.
First is that one has to be registered under the registration act.
My
is
lord,
not
may
there. He
clause
doesn't
D
have
Lordship.
any spare bus of his
Clause
own.
D.
Huh?
Clause D Lordship. There is no mention Lordship. Only says that Lordship, vehicles that are proposed to be provided must not be older than 5 years. The bidder shall have submit income tax return to employer.
Hello, we issue notice only.
Lordship.
Lordship can put it, direct them to produce that.
Oh, we'll ask him. We'll ask him to file affidavit.
Otherwise, Lordship,
I get your
He
instruction.
Considered when the
he has
Huh?
representation is there 21/7/23. I said. that-
Your representation, why? That is not necessary.
Lordship.
No, you want a disposal for representation? Or do you want the matter to be pending? No, I ask you. That is your lookout.
Otherwise,
You
also,
want, I can very well ask them that you consider his
the
representation.
decision making process is also not challenged, Lordship.
Anyways,
Yes.
the instant writ petition has been filed. Challenging.
Sitting order, let them dispose. it.
Huh?
Let them dispose
What?
of my petition, presentation. But I stated, my lord, that if you have given the same petition, I am also in a position to appeal, but you have not given it to the NIT. I may be hard and let.
We'll consider on next. Day. Issue notice making it returnable when?
After 4 weeks, Lordship.
Huh? Not for a week.
Lordship.
Issue notice, you get your instructions. I don't want anything else. Affidavit, you file it later. issue notice making it returnable on 21st of August, 2023. Mr. K. Gogoi appears on behalf of the respondent numbers 1 to 4.
Lordship,
Pustu. And extra copies of the writ petition be served upon him by 31/7/2023. As regards the respondent number 5, steps be taken by way of registered as well as usual. You want an early disposal by 31/7/2023. The petitioner is also further permitted to take steps upon the respondent number 5 by way of dusty, routed to the registry of the spot and file an affidavit of service on or before the next date. Now, registered and usual plus dusty. The case of the petitioner herein is that the petitioner did not participate in the said tender, case of the petitioner herein, that the respondent number 5 did not comply with that admittedly. Now, the case of the petitioner is that from the materials on record, it would be clear that the respondent number 5 is not the owner of the vehicles which he has submitted during the tender process. It is on the basis of a power of attorney taken from the owner of the registered vehicle. Owner of the is on a power of attorney taken from the registered owner of the vehicles that the respondent number 5 had participated. It is the further case of the petitioners that the respondent number 5 even does not have his registration as a is not also registered. Is not also registered as a travel agent, public registered handling agent under the Registration Act for providing vehicles on hire. It is therefore the submission that the respondent authorities have illegally granted the issued the tender, allotted the work to the petition respondent number 5. The Learning Town Senior Counsel appearing on behalf of the petitioner submits that had the respondent authorities made it clear in the notice inviting tender that these clauses would not be taken into account, the petitioner could have also participated in the said tender process. Mr. K. Gogoi shall obtain instructions in the matter as to whether the respondent authorities while granting the tender, while granting the work order in favor of the respondent number 5, have given a go by to the terms and conditions of the notice inviting tender. Necessary. What is there with the record? He will get. Huh? See, my basic philosophy is when the matter is before this court, I am not going to ask somebody to consider something. 48. Yes.
Regarding electricity connection, I have purchased a residential flat in 2014. As per registered.
You
agreement,
purchased a residential flat. Then what happened?
As per registered agreement, I have paid entire consideration amount to the builder. But is that the builder has not given registration to me before purchasing that flat, there was an electricity connection in the name of agent of the builder, but subsequently he disconnected on 15 May 2023. Hereafter, I had applied for new connection, but the authority has not given the new connection. Electricity connection.
How many flats are there in the building? How many flats? How many flats? Oh, get your idea. Because do you have a transformer? You have a transformer? No, no idea. I think you should ask all these things. Don't you think so? If you don't have a transformer, if it's a big flat, then how can they give a connection? Tell me. Temporary connection is given without a transformer. There's no problem with that. But can this connection be given? Now you are without electricity.
Now I am on temporary electricity.
What temporary? They have given?
Yes.
Then then
For
for that you have to pay more money.
more money.
Then
First of all, property of the electricity here, on application of an.
Mr. Pathak, does he have a transformer?
So I am not, there's been no mention of a transformer in the petition.
Anyways, we'll issue notice. You are having a temporary connection, na?
Yes.
Issue notice making, this is a quick notice.
Yes,
We'll have it on 7th of August.
perhaps he can take justice service on the private respondent because there
Who is the private?
there is a property dispute within the party.
Huh?
The builder here.
Or you take your justice service? No, we are concerned with what is the builder going to do?
Otherwise, clause 4.2 of the supply code, your lordship mandates that if the builder is the owner of the premises, then he has to issue a NOC in favor of the occupier.
No, you see, if the builder, there is some dispute to that
Yes,
affair, has given him the possession.
Yes.
Now you must have seen the builders, what they do, they once they have taken the entire money, then they ask these buyers out there to go this way or that
Yes,
way and
yes,
all these
that is-
things. It's a different thing. He can very well approach the RERA code. That's another aspect to the matter. But here the question of electricity is there.
Yes.
So you just get your instructions and you get your instructions as regards the transformer and all. But that is, I think that my reason is temporary initially connection was granted and thereupon he must not have paid or done anything to that effect, the builder.
Yes.
And this is the result of it.
16 May. Till date, there is 4 times temporary electricity connection. For that, I have given more than 40,000.
So I am giving you another 7 days. Wait, we'll look into it. You take service upon respondent number 5 by way of Dusty. Okay?
Information regarding.
We'll have it on 9th.
Very good.
Issue notice making it returnable on 9th of August 2023.
Or lordship may keep it for motion if I'll,
No, I don't disturb other people without.
very well,
instruction.
very well. Very well.
Mr. N. Goswami appears on behalf of the respondent number 1. Mr. KP Pathak appears for the respondent number 2, 3, and 4. Full stop. As the respondent numbers 1, 2, 3, and 4 are duly represented, extra copies of the writ petition be served upon them during the course of the day, today. Okay. As regards the respondent number 5, steps be taken by way of registered post by today. Full stop. Further to that, the petitioner is also directed to take steps by way of dusty routed through the registry of the spot upon the respondent number 5 and file an affidavit of service on or before the next date. Full stop. The petitioner herein is aggrieved by the disconnection so made by the respondent APDCL to his electricity connection. Full stop. The petitioner presently is having a temporary connection from the APDCL authorities and full stop. The petitioner, therefore, have filed the instant writ petition seeking a direction upon the respondent authorities to give him a permanent connection. Full stop. The Mr. Pathak, the learned counsel appearing on behalf of the respondent number 2, 3, and 4 shall obtain the necessary instructions in the matter. You are getting temporary.
Temporary up to 30.
Full stop. The temporary connection, electricity connection, which the petitioner is presently enjoying, shall be allowed to be continued till the next date. Subject to payment of the charges. We have it till the disposal of the writ petition.
Yes, Your Lordship.
Till the disposal of the writ petition, subject to payment of the necessary charges. 39. Yes. Mr.
My lord, the information notice, my lord. Page 18, my lord.
Page 18, yes.
18, my lord, copy to my lord, number 3, my lord, the secretary now Jame Masjid, the committee thing for information aspect. He is asked to immediately remove the construction and take down.
In the bank and the modification. Permission dated 20
And
inspection is
this
being
notice,
given.
my lord, is-
What permission is this?
My lord, if your lordship turns, my lord, page for a moment, my lord, page 13, my lord.
Ah.
A permission was given, construction.
Permission for what?
Page 13.
Permission is hereby accorded to so and so secretary of being so and so, who is paying for permission to construct the RCC GF building at so and so as it was the sanitary time, no any addition or alteration before construction official measurement must be. Okay, then
Then, my lord, page 15, my lord, notice has been served to us.
this was issued on 22nd of December 2021.
Yes, ma'am. By this time, at the RC.
Yes, so and so in the name of so and so is raised, notice is hereby given to produce relevant books and records, including land records relating to urgently required information for as well as to ensure that all relevant regulations are followed. Then you submitted your documents,
Yes, my lord, on 16th, my lord.
then
Page 16, I have submitted.
page 18.
Page 18, my lord, first of all, your lordship may see the dated, my lord, 20th April 23. At top, my lord,
Ah,
there is a notice of 20th April 23. Whereas, my lord, in the body, my lord, third line, they are referring to a letter dated 3/5/23, my lord.
yes. Hello. What do you have to say?
Lordship,
What do you say? What
we
is
have
it?
received some complaints,
You
Lordship.
issuing him a notice on 3/5/2023.
Lordship.
You pass an order on 24/2023 here. What is all this? I would have understood there might have been one mistake. But the mistake continues again down below also 20th of April 2023. But again, the permission number, you see, the permission date is different.
Yes.
They have made all the mistakes, you see. His permission is of 22nd of December 2021. And here, which has been held to be invalid is 22nd of December 22. Something must be wrong with your typist, isn't it? Who has made a mess up of all the dates. Hello? Issue notice when? Instructions?
3 weeks, Lord.
3 weeks. Issue notice making it returnable on 1st of September 2023. Mr. N. Goswami appears on behalf of the respondent number one, all
No,
respondents.
1, 2, 3 and 5.
1, 2, 3, and 5. 1, 2, 3, and 5. So you appear for the executive officer.
Lot.
Extra copies of the writ petition be served upon him by 31st of July 2023. As regards the respondent number 4, steps be taken by way of registered as well as usual by 31st of April 31st of July. I go to 31st of July. 31st of July 2023. Dusty. The petitioner is also permitted to take steps upon the respondent number 4 by way of Dusty, routed through the registry of this court and file an affidavit of service on or before the next date. The case of the petitioner herein is that the petitioner was accorded permission by an order dated 22/12/2021 by the executive officer of the Dhing Municipal Board. Thereupon, the petitioner, on the basis of the said permission, constructed the building in question. To the utter surprise of the petitioner, on 3/5/2023, a notice was issued by the executive officer Dhing Municipal Board asking the petitioner to submit the required documents as well as the building permission for the purpose of construction of the said building. Pursuant thereto, on 31/5/2023, the petitioner duly submitted the said documents. Full stop. To the surprise of the petitioner, an order was issued even prior to the issuance of notice on 24/2023 by the executive officer Dhing Municipal Board, Nagaon, whereby the permission so issued to the petitioner on 22/12/2022 have been held to be invalid, and it is under such circumstances that the petitioner has approached this court, apprehending that in view of the said order, the respondent authorities may take steps for demolition of the building in question. Taking into account the above, this court prima facie is satisfied. This court is of the opinion that the petitioner has been able to make out a case for a direction upon the concerned respondent, upon the respondent authorities, and more particularly the respondent number 5, not to take any course of action against the petitioner till the next date.
I know 41 for admission.
Oh, yes, tell me.
I'm appearing for the petitioner as a challenge to a service tax order.
You are challenging a order,
Service tax demand order.
demand order, yes. Tell me why.
So the other side has taken an objection in relation to my petition by relying on it. I have to meet the objection in relation to the instability of the petition. Mr. Rohan has been appearing in the matter.
Who?
Mr. Rohan has a counsel from Bombay. Appearing in the matter. So that it comes to the source of this matter in 5 cases. It is not be taken up. In fact, these are not daily factors matters. What's the code right now? Here's a genuine difficulty. I'm really requesting the matter we get to state. We'll go to the matter finally for disclosure. So I am saying that I fall under the exception in relation to the law laid on by commercial. In fact, in my petition, I have relied on commercial. to say that the order is without jurisdiction and breach of principles of national law. Your Lordship, I am only requesting Mr. Shah has a genuine difficulty. In fact, he has appeared, I have all the list of dates he has come. This is the board for all 5 days of the Bombay High Court. The first matter is on every day. In which he is briefed in the matter. He has genuine difficulty, Your Lordship. I am requesting to be kept on Tuesday or Thursday next week. To definitely come to it. I'll be the matter coming here.
Anyways, he need not come. Why is he not using this virtual mode?
So if you had in fact asked that is permissible, I was,
That's very much permissible.
no, I was.
We in Guwahati High Court allow it.
For you, I got instruction that it is not. permissible.
Absolutely, it is permissible. You can very well appear from there. He need not come here. It is, however, it's always a pleasure inviting people to come out to Guwahati. It's a different thing, but he can very well appear from there.
It's at 11:36 in Bombay High Court today. I think the board, what I have to do. I'm only requesting we can fit Tuesday. Will definitely come physically. So I will be here. Will argue the matter. Will have to be will have to meet the condition. Will definitely satisfy the maintenance.
Mr. Counsel, I'm not fixing it on Tuesday. I'll have it on Wednesday.
Tuesday, possible, Your Lordship.
Not possible. These are not matters for being taken up on so and so. We are only on the question of maintainability. First satisfy this court on maintainability, then we'll hear the matter on lead. But if it is not, we'll dismiss it. Maintainability question is short.
Absolutely, Your Lordship. As I said, we have taken argument to say the order is without.
Once you overcome the question of maintainability, then the question of will go on merits. Merits will decide whenever it is possible.
Absolutely, Your Lordship. We will be ready. Only request to either Tuesday or Thursday next week for my humble request.
We'll have it on
The last opportunity.
It's okay, no problem. But I'm not fixing it on Tuesdays and Thursdays. You want where I can fix it on 8th of August, on 7th of August? He can do it by virtual mode.
Fine, fine.
7th,
We will appear virtually if permission can be granted. We'll appear virtually if permission can be granted.
7th.
Seven.
The counsel appearing on behalf of the petitioner submits that the petitioner, that the said counsel is led by, what is his name?
Mr. Rohan Shah.
Rohan Shah, is a senior counsel by Mr. Rohan Shah, a counsel from Bombay. And he is in the midst of apartheid before the Bombay High Court. And as such has requested for an accommodation today to list the matter on 7th of August 2023.
It's an ad interim order.
We will hear on that day. I'm not satisfied. I'm not going to
Your
extend.
Lordship, only for those that days. We'll definitely
I'm not
declare for-
extended
only
yesterday
till
also.
The next hearing, Your Lordship.
Unless you satisfy this court as regards the maintainability, I am not extending the order.
The first order which extended was what at length only after making submissions on maintenance. The first order will die. The order will judge both the matter at length, including on the issue of maintenance.
Then you have to argue, you have to prima facie show that there is something wrong with the order. We'll hear on the maintainability on the latest, thing, but you have to prima facie show that this order needs continuance. I don't continue orders just for the sake of it. I hope your learned friend must have told you, don't extend the interim order just for the sake.
Lordship, as a last opportunity.
Last opportunity for what?
For the extension, I thought 7th will be.
Yesterday he asked for 1 day, I gave him 1 day. Then you should have been prepared. You have come from Bombay. Then why you are not prepared? Read the file. Satisfy me for extension. Only on extension.
I have prepared your Lordship.
Fantastic. Then we'll take it up.
Only on the, I'm only.
Only on the extension, not on maintainability, yes. On the writ petition being maintainable, let us assume the writ petition is maintainable. Then why should this court pass an order for stay? You submit that.
I'll say only on the maintainability issue, I'll just totally.
Maintainability, we are not now. We'll hear Mr. Rohan Shah on 8th. You just satisfy me why you are entitled to a stay. Yes.
Lordship, if I may, the compile issue, I have handed it over to you.
Hmm.
The Lordship may see page 107.
What is the issue?
So that is what I'll just come to your Lordship. There is a one small sheet which I have handed over as a chart.
Yes, that is a better one.
Your Lordship.
Yes.
Essentially, I am a bottler who does contract bottling for manufacturing of alcoholic liquor beverage. So traditionally, it is a well-established practice that there is a brand owner and there is a bottler who does the bottling. Why you need these two separate parties is, as a local party, as a bottler, I have the license under the local excise law to procure the raw materials like DNA and also to make a sale of the liquor. The brand owner does not have the license locally here. So the brand owner requests me to bottle and also sell on his behalf. I operate purely as a service provider who does the contract bottling services. Now, this issue has time and again have come before the board as well as before the tribunal and went up to the Supreme Court. The issue is what is my role? I'll just take you through a lot only in relation to two circular and one prescribed decision went to the Supreme Court and affirmed. The view that is taken is, I as a service provider provide a service to the brand owner. And there are two kind of,
You are the, what is your business?
I am a contract bottler.
You bottle.
I just bottle the,
So you bottle the liquor
I bottle the liquor.
and then you say, give it to the brand owner.
So Lordship, I procure the raw material for the brand owner. I bottle it, they give me a right to use their trademark and brand names, etc. I then use it to bottle it and I sell for their behalf. Entire profit goes to their kitty. The profit, what they calling it as the brand owner surplus. Let's say today there is a transaction where I procure on their behalf and I incur certain expenses while rendering my service and I make the sale for 100 rupees. If your Lordship, please see the chart there. The 100 rupees is what I have with the sale price of the alcoholic beverage. I as a bottler make the sale because I am the only person who can make the sale in this as per law. In that 100 rupees, there are three amounts that are comprised of. One is the 40 rupees, which is my charges. What they call it as a retention amount, a free retention amount, my service fee, for which I actually pay tax, no dispute at all in this. That 40.
For that you have already paid the GST.
I have paid service tax, I have paid GST, everything I have paid. I have not only paid on my 40 rupees as my fee, that 40 also includes certain reimbursement of my expenses to render that service, which is basically 30 rupees is my profit, but 10 is actually the expenses which I have incurred to render that service. I have paid tax on the entire 40. Now, there is another portion, which is 20 rupees, which is basically my procuring the raw materials for and on behalf of the owner, brand owner. And then there is 40 rupees, that is the profit which I have to give it back to the brand owner. The law is very clear. There is a board circular clearly on this to say, one, a brand owner surplus is a profit which is taxable under direct tax. It is not a service tax that I levy. It is not something which I come to me. It's not an indirect tax, leviable tax at all. It's a settled position for last 13 years, including by a Supreme Court judgment, today they seek to levy the tax on that in my hand. It is the brand owner surplus, which is his profit, they seek to levy tax on my hand. And on the reimbursement, if the raw materials that procure on his behalf,
So that
I-
tax will be like an income tax.
that is an income tax which he will pay. There's nothing to do in terms of the service tax. And that is the reason why I'm saying only without jurisdiction. In teeth of the binding boards of the law, the law is clear. You're doing something as a department contrary to the board circulars. It is void ab initio. That is what the Supreme Court decision says. And it's the teeth of the Supreme Court decision. And also your lordship, on the reimbursement, I made an argument, detailed argument to say that on the procurement of raw materials, I act as a pure agent. As a pure agent, the concept under the service tax rules, once I am a pure agent, then I am not liable for the tax. I'm not even getting into the merit. In the order, there's not a whisper of that. He's not dealt with it. So complete non-application of mine, the non-speaking order, there's a Supreme Court decision which categorically says a non-speaking order is a basic principles of natural justice. Once there is a non-speaking order, where would I go to the appellate authority to even make a submission to say that this is how they've applied it, this is the position, and this is why I am saying it is wrong. So my issue today is I have raised 4 or 5 basic issues with respect to the order. Number one is that the order seeks to levy tax on a brand owner surplus is wholly without jurisdiction, ultra varies the charging provisions of the Service Tax Act. Without getting into any fact, admitted fact, we are not getting into the fact. Number two, on the pure agent, the reimbursement issue, the arguments that I have made in my reply and in the written submission, he has extracted in the order, when he extracts all my submissions, he says this is the reply filed by the assessor. In the discussions and finding not even a word about it. So that I am saying is a direct breach of principles of natural justice. And third, there is a Supreme Court judgment your lordship, the law is settled as a nature of statutory and binding precedent
Where is that?
on the
Which
issue of
judgment?
brand owner supply.
Which judgment?
Kamlak Public.
You have given?
I have given the compilation.
Yeah, show me.
Also, the Godrej Tara, the latest Supreme Court judgment refers to Kamlak on both the maintenance issue and also on the aspect.
This, you are referring to this one, Commissioner of Customs, Calcutta.
No, your lordship, Kamlakshi is at item number 9, page number 28. But if your lordship would give me an opportunity, I'll read the item number 14, which is at page 67. 67, your lordship. Because this is the latest decision of the Honorable Supreme Court.
This I have read it. This is the judgment of Justice Ravindra Bhatt and Dipankar
Yes,
Datta.
yes, yes. And there is also Justice Chandrachud's judgment on Radhakrishnan 2021. That also lays down the principle. But here your lordship also sees the issue on page 75 at para 34.
Hmm?
Page 75.
In view of the
para-
revision might have been justified in exercising the sumo to para 34.
Para 34. May I please read it, your lordship?
Para?
Para 34, para
Yes.
34. But I'm just reading it at the last 3 sentences. Unless the discipline of adhering to decisions made by the higher authorities is maintained, there would be an utter chaos in administration of tax laws apart from undue harassment to others. We share the view expressed in Kamlakshi Finance Corporation. Kamlakshi Finance exactly says this binding precedent, you cannot just simply kind of step over and say that now I will come up with a new view. You then also go to the High Court and the State Court, etc. The view on the brand owner surplus in terms of the
Where is that judgment?
on the Kamlakshi Corporation at page 20.
Page. Page.
Page 28. I'm sorry. Page 28.
Page 28. Yes.
I'm just referring to para 6. Somewhere in the 6th line. The
Yes.
High Court has in our view.
No, Mr. Counsel, read it from the top. I know you have less time.
No,
But
I
then
know.
also read it
And
from the
the
top.
six-
Yes.
The respondent manufacturers,
Para 6?
para 6.
Yes, Mr. Reddy.
Yes.
P. Reddy is perhaps right in saying that the officers were not actuated by any malafide passing the executive order. They perhaps genuinely felt that the claim of the assessor was not tenable and that if it was accepted, the revenue would suffer. But what P. Reddy overlooks is that we are not concerned here with the correctness or otherwise of their conclusion of any factual malafide, but with the fact that the officers, in reaching their conclusion, passed two appellate orders, bypassed, I'm sorry, bypassed two appellate orders in regard to the same issue which were placed before them, one of the collector appeals and of the other tribunal. The High Court has, in our view, rightly criticized this conduct of the assistant collector and them in the harassment to the assessee caused by the failure of these officers to give effect to the orders of the authorities higher to them in the appellate hierarchy. It cannot be too vehemently emphasized that it is of utmost importance that in disposing of the quasi-judicial issues before them, revenue officers are bound by the decisions of the appellate authorities. The orders of the appellate collector is binding on the assistant collector working within his jurisdiction, and the order of the tribunal is binding upon the.
Okay,
the
these,
principal
no,
judicial decision.
Mr. Council, we are, okay, but where is the appellate authority or any order to
I'm
this
just showing-
way?
I'm showing a lot. I'll show it in two parts. I'll show the circular first, then I'll show the Supreme Court order.
No,
Because
no,
the
show me the
order-
Supreme Court. Circulars are not
Okay,
binding.
I'll show the order. Supreme Court.
Yeah.
Lordship may
Show me
come
the
to,
Supreme Court.
the Lordship may come to page 20. I'll show the tribunal order which has been
No, no, page,
page 20.
Yeah.
Page 20. This is the.
No, no, no.
tribunal order.
show me that order of the Supreme Court, where?
Lordship, this is what has then gone to the Supreme Court, which is at page 19. Supreme
Page
Court-
19.
Page 19 is the Supreme Court order. I'll
Yeah.
have to show the tribunal order first and then come to the Supreme Court order.
Yes, let us see page 19,
Page 19, paragraph 4.
comprising of so and so and so and so. Demand after condoning the delay in calculated.
This clearly says devoid of any merit, disposed of threshold. They hold it at length. To the tribunal. That quietly over.
Yes,
The tribunal judgment is at page 20.
so the Supreme Court only dismissed the SLP.
Lordship, that's what I'm highlighting at paragraph 4. Really says, having carefully gone through the records and hearing learned counsel for the appellate, here of the considered.
No,
opinion
Mr.
that the
Council, no, Mr.
he
Council,
is void of any merit.
Mr. Council, unless the leave is not granted, it does not transform into a civil. It is an SLP.
Even without getting into the Supreme Court judgment, can I show the tribunal judgment
Yeah. Tell me.
at page 20?
Hmm.
The Lordship may kindly come to page 23. I'll just.
Page
refer
20?
Page 23.
8.
23. Page 23. Somewhere in the
This is,
There's
this
a
is what.
surplus.
Now let us see what did the tribunal say?
Yes, your lordship, the finding I'll say, your lordship, if you don't mind, I'll just show you surplus which are
On
extracted.
merit, we hold the appellant is not liable to pay service tax on the category of activity. Yes,
May I read the surplus, your lordship, because that's very clear.
where?
At page 23, there is a reference to a CEC circular dated 27/10/2018.
Hmm.
It starts with the word further, we find that the appellant has relied on. The where the issue is to be done. So there, the entire industry background and the manner in which each party have operated in a separate kind of methods. Contract bottling is one of them.
So, Mr. Counsel, the issue involved here is as to whether the bottler is liable to pay service tax on the profits earned by the
Brand owner.
brand.
Absolutely.
It's a question of law.
Which is what I have also.
Mr. Counsel, is it a question of law?
Lordship, yes, your lordship, it was by your lordship.
Telehawk, yes. Your name?
Lordship, I'm. if party and other are request your lordship, please get the date when this-
What is your name?
Sabari Rajan.
Naam to likhe. Madam, we hold that repetition is maintainable because it is a pure question of law.
Yes.
And it is a pure question of law, so obviously this needs to be adjudicated. And we continue the stay till we'll take it up for disposal. Yes, now tell me, when do you want the disposal? Okay. IA Aswan, na? You have filed an IA.
No, your lordship.
No, your lordship, that was an IA filed by me because there are some references to article 90.1
Okay.
in the petition.
Well.
Individual activity.
The issue involved in the instant writ petition. The writ petitioner herein admittedly is a bottler. Carries on the bottling service for
Brand owner.
various brand owners.
Yes, various brand.
The grievance of the petitioner herein, for which the order dated 25/3/2022 issued by the Principal Secretary, CGST and CX Itanagar have been assailed along with the show cause notice dated 27/4/2021 and have been assailed is that the respondent authority have not taken into consideration the relevant circulars issued by the Ministry of Finance / the board while passing the impugned order dated 25/3/2022. The learned counsel for the petitioner, Mr. So-and-so, submits that a pure question of law arises for consideration in the instant matter. as to whether the profits earned by the brand owner whether the petitioner, who is a bottler, would be liable to pay service tax on the profits earned by the brand owners for whom the petitioner bottles their liquor. The IMFL, na? Bottles that. The same aspect, taking into account the judgment of the Supreme Court in the case of, where's the judgment? Dipankar Datta, Justice Dipankar Datta judgment. Huh? 850.
67, you know.
Taking into account the judgment passed by a recent judgment passed by the Supreme Court in the case of MS Godrej Sarali Limited versus the Excise and Taxation Officers, come Assessing Authority and others, reported in, what is the TMI? Is that a 2023 bracket 2 TMI 64?
Para 8 is the aspect of your. Para 8.
Wherein it has been held that where the controversy is purely a legal one and it does not involve disputed questions of facts but only questions of law, then it should be decided by the High Court instead of dismissing the writ petition on the ground of alternative remedy. This court is of the opinion that the question, that the issue involved herein is a pure question of law. Taking into account the above, this court is of the opinion, taking into account the above, this court negates the submission of the respondent authorities that the instant writ petition should be dismissed on the ground of alternative remedy. This lists the matter again on when? Now.
8 after 15th August.
17th of August.
Right.
On 17th of August 2023 for admission. The interim order passed earlier shall continue till the disposal of the instant writ petition.
For admission item number 4.
They are allowed to run a train. They are allowed to run a transport train, my lord, which runs from Bangalore to Guwahati and back to Bangalore. So, my lord, there was a my lord, 850 is a letter awarding me, my lord.
Has Mr. RKD Chaudhary's name shown?
Yes, my name was here only, my
এই আওয়াজ তো ঠিক করা নেই আমার no, as he's not there, we'll have it on some other day. Hmm? We'll have it next week. List the matter next week. Taking into account that Mr. R.K. Deep is not present in the.
Timing item 1.
Yes, what is the status of the acquisition proceedings? This acquisition is done under what provision? Notification has been issued? Then? So the acquisition proceedings have not started. Then-
Time consuming, my lord, time
Then-
consuming purpose.
How can this court think about it?
That is not declared by the authority also. Petitioner paid out the amount on after proper calculation.
What are the discrepancies?
Regarding the reduced rate of period for public period, reduced from 10 to 12 to 10%. Now they have calculated.
Have you calculated it? Then you don't have a case. Then why you are not approaching them? Have you approached them how much you are going to pay? Where? Pursuant to this communication, where have you represented? When?
February 2020, at page 20.
Hmm?
Page 20.
That was given in 2022,
Then
more than 1.5 years back.
Page loss. 40.
Page
Page 40.
40. Where is the enclosed list to this communication?
The last page, my lord.
Hmm?
That's a page 50, sir.
No. Kindly come to page 42. As per you, what is the amount? Huh?
2,80,11,000.
Page number?
Main petition.
Second floor, is to be mentioned.
This happened in the year 2022. Thereafter,
Thereafter,
what about the year next year?
next year was.
Because notice of, as per you, you have stated the amount to be 2 crores in the year 2022. Didn't it? Then what happened in the meantime thereafter? Have you been regularly paying?
Others are like salary, everything is paid except this provision matter.
That is it. Are you not deducting it from their salary? You are deducting it from their salary, then I'm not concerned with the loss. Close down, ask them to sell it. Better off. Let them sell it.
Some time maybe money and some time maybe in the always consider it 50 lakhs. That amount will be paid.
Huh? By 14th of August. We'll consider then you pay. Otherwise, the interim order gets vacated. Let him pay 50 lakhs. We'll consider that. Issue notice making it returnable on 16th of August 2023. Mr. N. Goswami appears for respondent number 1. Mr. N.C. Das appears on behalf of the respondent number 2, 3, and 4. As the respondent numbers 1 to 4 are duly represented, extra copies of the writ petition be served upon them during the course of the day. The petitioner herein have approached this court challenging the action of the respondent number 2, 3, and 4 in initiating steps for sale of the garden, petitioner's estate, by the notice for settling a sale proclamation dated 14/7/2023. From a perusal of the petition, it is not clear what is the exact amount the petitioner is liable to pay to the respondent number 2, 3, and 4. However, from the notice dated 7/3/2022 issued by the respondent number 3, it appears that an amount of rupees 3,39,14,190.62 is the amount payable.
As per your recovery certificate, my lord.
That is 7/3/2022. Mr. N.C. Das, the learned senior counsel, however, submits that as present the petitioner's total liability is, you just said now from 4 crores something, na?
It's 4 crores 38 lakh 59,614.24.
On the other hand, the learned counsel for the petitioner submits that at the time of initiation of the recovery proceedings dated 7/3/2022, as per the calculation of the petitioner, the total amount payable by the petitioner was rupees 2 crores 80 lakhs 11,376.50. He further submitted that there has been a payment of an amount of rupees 60 lakhs on Hmm? 9th of September 20. On 9th of September 2022. He further submitted no, 50 lakhs, not 60 lakhs.
No.
10 lakhs was-
Huh?
Total was
50 lakhs.
50 lakh, my lord.
total 60. Initially 10 lakhs. Thereafter,
It is, however, relevant to take note of that on 3/2/2023, the recovery officer of the respondent organization had issued a notice directing the petitioner to pay an amount of rupees 4 crores 38 lakhs 59,614.24. And it is on account of the default so committed. No, full stop. It further appears that on 4/4/2023, the recovery officer of the respondent organization pursuant to a request made by the petitioner to deposit 50 lakhs as mentioned in their communication dated 22/2/2023, directed the petitioner to submit the deposit challan of the said amount, and further directed that no further extension of time would be provided to deposit the dues. And the next course of action would be as per the recovery proceedings. Next course of action as per the recovery proceedings will be undertaken. The learned senior counsel appearing on behalf of the respondent organization submitted that as the petitioner have failed to make that payment of the amount of rupees 50 lakhs to which they had earlier agreed, the impugned communication dated 14/7/2023 have been issued. Mr. J. Kulte, learned counsel appearing on behalf of the petitioner, submits that he has instructions that an amount of rupees 50 lakhs would be paid by on or before 14th of August 2023 to the respondent organization by the petitioner. Taking into account the above, this court therefore stays the communication dated 14/7/2023 stays the notice for settling a sale proclamation dated 14/7/2023 till the next date subject to deposit of an amount of rupees 50 lakhs by the petitioner to the respondent organization. Respondent number to the Assam Tea Employees Provident Fund Organization on or before 14th of August 2023. It is made clear if the said deposit is not made till then, within the time above mentioned, the instant order shall stand automatically vacated,
Understood.
and the respondent shall be at liberty to take such action as deemed proper.
Item numbers 5 to 7.
Yes, what are these three matters?
Flyover is coming up at page. Suddenly page flyover is coming up at the government of
Flyover coming up where?
essentially page.
Then
What happened?
what are you asking for?
I am asking for my lord, if I am to vacate my lord, at least I should be compensated.
Oh, you are not compensated?
No, my,
Your land has been taken over.
till now not taken over, but my name is now reflected. First, what happened?
Reflected where?
Reflected the newspaper, I put the requisition and acquisition list has been provided.
This is done under the Assam requisition acquisition.
My lord, kindly see the precursor of the litigation, my lord, kindly see annexure 4.
Are you objecting to the acquisition?
No, my,
You are only concerned with the money.
now, my lord, there are two more aspects which I would like to highlight. The requisition was subsequently after filing of the requisition, the requisition process was initiated. But till that there is no further action. So far acquisition is concerned,
They have not acquired.
not acquired. So I'm.
Are you taking steps under section 6? There was a requisition, na?
Fine.
So they will have to take under 6 now. Are you taking it? But acquisition, I think, did not happen because the land you were still occupying.
It's still occupying, my lord, but.
So the
What
requisition,
happened, my lord, They
Yeah.
have not given a clear picture to most of the residents, except 2 or 3. There are at least 400 individuals, my lord, having their respective families. Only 3 have approached this honorable high. And after approaching, they published this. Otherwise, they were demolishing everything. Thereafter, they stopped. Kindly see an.
so they have stopped demolishing yours.
Yes. Kindly see annexure 4, my, what was the way they initiated?
Annexure 4 of which one?
Page 35 of my repetition.
They have filed an amended
The
petition.
construction of a flyover at Iman, both sides of the national highway will be extended for work to be initiated by the PWP Iman.
This is my-
Presently in the area, state area on both sides of the national highway where there is a reserved land for national highway, it has been listed illegally.
This notice, my lord, was a public notice without specifying as to who is the encroacher, my lord, what is the area he or she has encroached. This is the kind of notice which was issued, and thereafter the demolition is started. We approached, only 3 of us approached the honorable high court, we got interim protection. Thereafter, my lord, kindly see this is the amended petition that we have filed, my lord. What did we kindly come to annexure 7, my lord, page 43. In the month of September,
So they've gone for acquisition.
now they have
Requisition.
requisition. Now, kindly consider, my lord, in July 2022, they gave the impression that whosoever was there on the by the side of the national highway were all encroachers without having their Miadi Patta land.
Hmm.
So by giving such kind of impression, they started. This was only to obviate the payment of compensation. Now, my lord, in this case, my lord, my name definitely reflects, my lord. Kindly see the next page, page 44, my name is there, Daljit Cox, the middle portion. Now, again, here it has been shown that 3 families are there and only 3.5 lassa is being taken over. But the demarcation that has been given, I am reading page 44, my lord, annexure 7. My name is there.
What is your
Apart
name?
from me, my name is, the middle portion, my lord. Daljit Kaur, on the left side.
Daljit Kaur.
Daljit. Along with me, there are two more names, my lord. Punaram Miya is another family, and Rochester Miya. And if you consider the next column, my lord, you will find 3.5 plus of land, great site is
Hmm.
being taken over.
Three
Now,
lesser.
3.5 plus the.
Why you are saying 3.5?
3.5, my lord. In
It's
front
only
of
three
all names,
lessers,
my lord,
land
column
acquired.
Number, land acquired, yes.
It's three lessers. 0, 0, 3. Okay, then,
Now, my lord, again, it is not clear.
no,
as to whether-
3.5 is in the case of Gozen Soikia, Horen Soikia,
Everyone,
Daru
my-
Soikia.
3.5. My question, whether 3.5 from me or 3.5 altogether from three families, number one. Number two, the demarcation that has been shown at my residence, it is around 8 plus. So what you are going to do, whether, first of all, my question is whether you are going to acquire, if yes, the area and the extent to which you are going to acquire, and whether I am going to be compensated. No clarity is there, my lord. And most of the people, they have already taken out of anxiety.
Mr. Singh, we are not concerned with others. We are only concerned with the petitioners before.
Sure.
Now let me ask Mr. Borpuzari. Yes, Mr. Borpuzari, what is this?
Now, this writ petition, my lord, was filed initially challenging that, my lord, public notice, which my lord has just now seen, my lord, Annex 4, page number 35. It was a general notice. Now, what transpires from a plain reading of this notice is that, my lord, a rotary is going to be constructed, my lord, in Mission Sariali, Tezpur.
In the,
Mission
by
Sariali,
whom?
my lord, by the authorities of National Highway.
Then who are you?
I am not National Highway.
No, understood. You are not the national highway.
Not the
So it has to be, why you are initiating action under these?
That's what I was about to address, my lord. So one
This
by
has
one,
to be done under the National Highway.
National
Act.
Highway Act.
Then what are all these things being done?
So therefore, my lord, an affidavit from the deputy commissioner is required here to be filed.
No, you can't do all these things. So why you are initiating acquisition, the provisions under the Assam Acquisition
Yes,
Requisition Act?
that's what, that also hit my mind.
Then that's not possible because this is a land for the purpose of National Highway. The
Yes.
National Highway Act will apply.
Yes,
So it has to be done as per that. Then whether the National Highway is a party.
no, that's the difficulty.
How can we make, we are until.
No, it is their own pleading. In the pleading, my lord, there is specific pleading. There is a specific pleading in the writ petition that the land in question is sought to be acquired for expansion of National Highway. Meaning thereby, my lord, the National Highway is the authority who is taking all care and control, my lord, for it. Still, they choose not to implement National Highway.
Don't worry, we will do it.
That is one aspect of the matter. Secondly, Lordship will kindly see, Lordship has seen this.
No, he obviously he has not.
No,
When you are initiating under the Assam Acquisition
my-
Requisition,
yeah,
means what has happened? The government of Assam has taken it, the Acquisition and Requisition Act for a right.
now, Lordship,
Whatever is necessary, let us bypass of this right to fair compensation. Everything is acquisition and requisition.
that can be known on.
One case I got it, but that case, after the matter did not come before this court, I was supposed to pass that order. There was some BRPL Pradesh, Bongaigaon or no, Numuligo. For Numuligo, there was some acquisition to be done.
Yes,
You were there, nah?
yes.
What happened to that matter? It's still pending.
No, we got a favorable order.
See. How can they do all these things?
Lordship may kindly for a moment come to
Doing for
40.
everything.
Lordship may kindly for a moment come to page 40. 40 of the writ petition, my lord.
No. Why should I come to all these things? First
No,
and
because-
foremost, what is this authority to do on the National Highway Act? And why are you doing under the and on one hand, you write out there we are requisitioning under Section 3, and you say the land acquired is something. How can you acquire land? This is a notification as if it is a notification under Section 6.
Yes.
Then-
No, by now, therefore, I am inviting my lord to page 40. Kindly see page 40 of the writ petition. Kindly see.
Yes.
It is a notice.
Hmm.
My lord, written by the circle officer. In the land acquisition case number 2 of 2022 dated 9/9/22 of the Office of the Deputy Commissioner of Sonitpur under notification so and so, notice is hereby given to the landholders and other interested persons whose land has been acquired for construction of flyover bridge at Mission Seriali are asked to receive compensation by being present along with the below mentioned documents in the Office of the Deputy Commissioner so and so. Meaning thereby, my lord, section 6 notification might have been issued. So therefore, my
No,
lord,
no, no, no. You can't say that. Might have been. You are appearing for the respondents.
I am
So you have to know as to whether might have been, no. This is a writ petition pending since 2022.
No.
You are not aware of that.
no, they have filed this amended petition of late, my lord.
So what? They have got it now. You must have been knowing it.
No,
The,
this-
the writ of amended
this-
writ petition, amended writ petition was filed when? 27/7.
Yes.
And this was done in pursuance to an application for file for amendment and must be knowing it then.
Now, my lord, what transpired?
What order have you got?
They just state, this honorable court have stated that, my lord, general notice.
Supposed to any developmental project, but there is no clarity, because my learned brother is saying that it might have been acquired. There is no clarity whatsoever it says whether actually land has been acquired. Most of them have been revoked. No
Okay.
acquisition, no notification.
Lordship will direct the deputy commissioner to file a affidavit. My lord, that will clear the issue, everything. It has to be on question of fact, my lord. In
Why
fact,
should I direct? If it is not not done by you, are you both not standing out here to support the case of the deputy commissioner? Do it. If you don't, we pass an order not to disturb the possession of the petitioners.
No, that has already been there, my lord. This notice has already been stated by this honorable court.
Where is it?
Page 35. So it is the case of the petitioner.
Page 35 is
Page
what?
30. That is state.
Page 35.
Yes.
No, this notice has been stated. No,
But this
the
approval-
order which has been passed is not to take coursive action.
Yes.
Till then, no adverse action be taken against the patta lands of the petitioner pursuant to the impugned notice dated 1/7.
It is still continuing.
Yes. No,
Therefore-
don't do anything unless you are clear on that. You have no business. It is the national highway who may do if it is a national highway lane.
Therefore, I am submitting, my lord, these documents prima facie goes to show that an acquisition proceeding has already been initiated and it has culminated, my lord. I am saying, my lord, with all responsibility, my lord, there must have been an award already been passed.
Mis-
So otherwise, this notice,
Mr. Borbudari,
notice-
don't make
this
such vague submissions. Okay. It appears on records that on 27th of July 2023, the amended writ petition has been filed. Full stop. Copies of the said amended writ petition have already been served upon the respondents, upon the counsels appearing on behalf of the respondents. This court has also heard Mr. R. Borpuzari appearing on behalf of the Revenue Department. And it is not clear from his submissions as to whether the land sought to be acquired is in respect of other roads or national highway. This aspect of the matter has great relevance, taking into account that if the acquisition is to be made in respect of the National Highway, the National Highway Act 1956 would be the appropriate legislation on which in respect to appropriate legislation for the purpose of taking action. However, it appears that the respondent authorities, more particularly the Deputy Commissioner, Tejpur, have issued an order under section 3 of the Assam Acquisition and Requisition, Assam Land Bracket Requisition and Acquisition Act 1964. Whereby it has been mentioned that various lands have been requisitioned for the purpose of construction of a 4-lane flyover at Mission Sareli, Tezpur under Tezpur Revenue Circle. It further appears that although the said notice, said order states about requisition, but in the schedule mentioned therein, it has been mentioned that the land has been acquired. Which is, however, contrary to Section 6 of the Act of 1964. Taking into account that the respondent in the Revenue Department and more particularly the Deputy Commissioner Tezpur is not clear in respect to the said actions, this court directs the said authorities to file their separate individual affidavits before this court. On or before 17th of August 2023. List the matter again on 23rd of August 2023. The interim order, the respondents in the instant proceedings are directed not to take any action on the basis of the order dated or the order issued under Section 3 of the Assam Land Requisition and Acquisition Act 1964 till the next date.
So should we also kindly mention the land LA case, my lord. It is LA
In LA case number
1/2022.
1/2022. All the three same, na?
The other two are a bit different because so far requisition and acquisition, it has not taken, my name doesn't reflect the newspaper item.
But it is for the same reason they are doing it.
Yes.
We will have all the same, all the three same order, order.
So that page 40 circle.
But here you have not filed any affidavit, addition affidavit.
Additional affidavit because there is no reflection of my name subsequently.
Okay, list the matters along with WPC number 4921/2022. The interim order passed earlier shall continue till then. On 16th, no? It is date fix kursu
23rd.
23rd. Huh? It yes.
But the reply has not been filed by.
You have not filed?
My lord, no, my lord, I pray for 7 days time, but my lord, the contract agreement has not been annexed. The issue is that, my lord, while releasing the running bills, GST has not been, my lord, deducted. So what was there in the contract?
Directing
will have
for
to be placed
making
before
a
our-
payment of the GST to the running bills to the petitioner and
The
also
company
add
can-
GST to the future.
Okay, maintenance.
Still going on, my lord.
No, Mr. Mr. Chakravarti, kindly appreciate one thing. If you don't enclose the contract, how are we going to know what is the terms of the contract as to whether it is inclusive of the GST or excluding the GST. Mr. B. Chakravarti, the learned counsel appearing on behalf of the petitioner, file an additional affidavit bringing on record the contract agreement on the basis of which the relief has been sought for. List the matter again on how much? List the matter again on 9th of August.
Anyone 9?
Yes. What is this?
Non-payment of contractual fee. Lordship, in this matter, I would like to pray that 2 weeks time may be granted so that I can file my affidavit, Lordship. If some,
Non-payment of contractual bills.
some part payments have been made, Lordship.
How, what is the court fee you have paid? Only for one? And you are asking so many for so and so? It appears on record that there are 5 petitioners. However, claiming the individual right for payment of their contractual bills. However, a perusal of the writ petition shows that only the court fee of one petitioner have been paid. The learned counsel for the petitioner submits that he would pay the deficit court fee on or before the next date. Mr. C. Sharma, appearing on behalf of,
Respondent number 123,
what is that?
water resources.
Water Resource Department of the Government of Assam, 6 for an accommodation to file a reply, taking into account that certain amounts have been paid to the petitioner. In that view of the matter, list the matter on 23rd of August 2023. In the meantime, the respondents shall file their affidavit.
10.
Yes. Both of you were supposed to take instruction. Have you got the money?
Lordship, no, Lord.
Why? You have not paid him because the higher education department have not released it, isn't it?
Yes, Lord.
Where is the higher education department?
He was to be.
Taking let the matter be listed on so and so on which date the learned standing counsel appearing on behalf of higher education as well as the respondent shall apprise this court as to what is the status as regards payment. Yes,
sorry.
why haven't you released it to him? To him.
It may be possible for the time being, my senior has instructed.
Oh, no, today I can't. We'll have it on next week.
My lord.
Yeah, there he is. Yes, what is your instruction?
Lordship, I have yet to receive instruction, Lordship. Let it come next week, Lordship.
Mr. D. Upamanyu, appearing on behalf of the Higher Education Department, 6 for an accommodation so that he can obtain the instruction in terms with the order dated 19/7/2023. Mr. MP Sharma, appearing on behalf of the respondent number 4, submits that as the amount has not been till date approved by the Higher Education Department, the payment have not been disbursed. They are going to pay you, na?
Lordship.
Disbursed by the Higher Education Department, the said amount could not be not
Release.
sufficient to clear the amount as upon has not been able to disburse the amount to the petitioner on account of the amount being not paid by the Higher Education Department. List the matter again on 16th of August 2023. On which date both the councils appearing for the respondent number appearing on behalf of the respondent shall obtain the necessary instruction in terms with the order dated 19/7/2023.
Highly obliged.
11.
Yes, what is this matter?
Or the petitioner is petitioning in person.
For what?
My lord, he is petitioning in person, my lord. He has
Understood. What
challenged
was the matter about?
The matter is, my lord, my lord, this court below has extended the time period for conducting the arbitration in exercise of power under section 29A. My lord, the petition.
Oh, this one, it cannot be extended.
Cannot be extended.
Yes, there he is. Yes, tell me.
Last time, Lordship has told me to bring the Supreme Court decision
Hmm.
of section 11 and 15 for that is for the appointment of the substitute arbitrator after the termination of the thing. This is what I-
Appointment of an arbitrator outside the,
the appointment of substitute arbitrator in place of already terminated mandate of terminated.
Ah.
This lot told me, I asked me to bring this
who has appointed that
arbitrator appointed by this honorable court of.
and substituted?
Now we are going for the, by this,
Okay, okay. So it has to be done under by whom?
by this honorable court of
Under section 11.
11.
Then have you moved that?
No, sir, first of all, the thing is altogether some difference there. The
But
matter
what do you have, I have to say about 15?
Lordship, 15, I have brought it to discussion.
Yes, 15, what does it say?
Lordship, basically what happened is the
Has the award been passed?
Yes, my lord, the award has.
Award is passed during the pendency of the matter over here. This honorable court said award should not be passed. But in spite of having that instruction, the arbitrator has passed the award.
When?
Lordship, I have submitted that an extra flag C is there, Lordship.
Understood. Where is the order? Where the court said that no orders, award should be passed.
Lordship,
According may file an in view of the submission, none of the parties have taken extension and as such of the term of the arbitrator as such the impugn order is liable that this court finds it extend to look into arbitration. Where is the order by which this court says that no award should be passed?
Lordship, order is as pages of 71 and 73 of additional affidavit.
Additional affidavit file,
Second February 23. order.
page,
Page 71 to 73.
however, so and so, and file objection and not been included. for instance,
Last paragraph.
Huh?
Last at page number 73. Lord.
Yeah, Mr. Dhiman may file application. We have to adjourn the proceeding which is fixed on Dhiman citing reasons of pendency of the present. Then what happened?
Then the Lordship, I have on 74, I have filed an application
Then
then also email, but thereafter some time at page number 76, they passed an award before calling, without calling.
so if the award has been passed, don't you think that you have to challenge it under 34 now?
Lordship, the arbitrator has gone against the order of this honorable.
No, this court did not pass an order. The court said only that to file for you to go and file an application, making him a request that there is a matter is pending. The court did not pass a stay order, Mr. I think the best option, I think you need to challenge it under 34 now, the award, saying that it is without jurisdiction.
But they the arbitrator has overruled the order of the honorable.
Where?
This is the bypassing the award, Lordship.
Mr. Counsel, Mr. Petitioner in person, that is not, there is no order passed by this court. The court says that asking you go to the arbitrators, inform him that there is a matter pending before this court, not to pass an order or not to do anything. See the language of the order passed by this court. See, Mr. Dhiman may file application before the learned arbitral tribunal to adjourn the proceedings which is fixed on so and so, citing the reasons of the pendency of the petition. That's all.
Lordship, I have filed the application.
Understood, but is there any order passed by this court not to pass? No.
Lordship, it will multiplicity of suits will be there and already.
But no, understood, but how can I now touch it? Once the award has been passed, the only manner in which you need to challenge is in 34.
But Lordship, there are several high court decisions is there when the order has already been passed by the arbitrator to adjourn the proceeding. Even in spite of that, it passes the order that can be challenged.
Where?
There is a nil award.
Understood, you can challenge under 34,
Lordship, it will take long time.
but I can't help you with this. I can't challenge. How can you? There is no stay order. If there was a stay order, obviously this court would have passed. The best only way is that, think about it. I will pass over this order to the matter. When do you want it? But this matter is going to again revolve and come back to me.
On 14th,
Eh?
on 14th of August.
Why? Before independence.
No, my
Yeah.
case is already fixed over there. Yes, on 14th.
The learned counsel appearing on behalf of the petition, no, the petitioner in person, submits that you would look into the aspect as to whether the present proceedings would continue to be can be maintained, taking into account the award has already been passed by the substituted arbitrator. List the matter again on 14th of August 2023.
12 and 13.
Because you see, when was the award passed? June? Okay, because otherwise again 120 days. You'll have a lot of problem later on, huh? Because 90 days and another 30 days. Then Mr. Gupta will have his last laugh. Maybe, but then also, na, you know now.
I want to, I have already something wrong in front of the Lord.
Ah.
That has not been released. That is not correct.
Mr. D. Gogoi is going to appearing on the submit that he would like to produce the records on the basis of which the communication is the matter on the day healthy calendar. What is the refused to register the register there? Yes,
But if we have received the instruction, some time may be given to bring it on record.
I've only asked you to get your instruction. What is your instruction? Like to produce the record on the basis of which the communication dated 1/9/2017 was issued. Have you got the records?
We have not got the record, but
Get your records. I've asked for the records. I'm not asking for anything else. He would like to produce the records. He himself stated, Mr. Gogoi had stated on the last occasion that I'd like to produce the record.
Lordship, we would like to file an affidavit.
When this court have asked for records and you are asking for affidavit, you don't want to produce the records. Okay, we call which is the official? We call him. As you say that in spite of the
Lordship,
order
but-
passed by this court, you are not producing the records, we call this person, the additional PCCF.
Lordship, we'll produce the records
When?
next week.
Monday.
Sure.
And Mr. Gustami, what about this thing? Why haven't you registered the sale deed?
No, I'm doing apology. That's already I have.
Register,
I was informed. Filing this date petition, they did me.
because I was surprised when they were there. Yes. Okay. The council appearing on behalf of the forest department submits that they have already received the instructions and would file the affidavit as well as also produce the records. Full stop. List the matter again on 16th of August 2023. On which date? The forest department, the council appearing on behalf of the forest department shall ensure that the records are placed before this court. Full stop. Mr. B. Sharma submits that inadvertently he had stated that the sale deed had not yet been registered. Full stop. He submits that the sale deed have been duly registered in favor of the petitioner. In favor of the
Intending part, we have told you. Ending.
then where is your cause of action?
Because 3 bighas is there. 13 bighas is there.
List according.
14.
Obliged.
Yes.
What's happening with the of a vehicle. That particular vehicle had an accident at Fukushima, Dimapur University.
Oh, you can't go to Dimapur.
At that point of time, the situation is such that it's getting get call from the other, the other.
Now you want to go.
Yes, sir. And the compromise talks are going on and initiating.
So you don't want to press. Mr. G. Bodley, the counsel appearing on behalf of the petitioner submits that at present the matter between the petitioner as well as the respondent,
It has not been made party of.
submits that the petitioner, the apprehension of the petitioner on the basis of which the instant writ petition was filed is no longer there in view of the change in circumstances, and as such the petitioner would not like to press the petition. In that view of the matter, the instant writ petition stands closed on withdrawal.
15.
Yes. What is this matter about?
By the non-payment of
Non-payment of?
contractual
By whom?
by the irrigation department. It's the report of the regional chief engineer of the board.
Where is the irrigation department? See? Get hold of them at 2. We passed away, dispose it of, directing them to make the payment in terms with Taslim Ali, or what is that? Tamsir Ali. It's already been done. So then how the payment will be made within? Because in other irrigation department, Miss Neog appears. DS Neog. We'll have it or some other day. Because today I'll be rising early. Okay. This is the matter next week. Taking into account the none has represented the irrigation department today.
16.
Sige. Say more. Beleg to.
Seventeen.
Execution. So pass that, verify and make payment.
No, in fact, we have received the instruction. As per this, as Gracia of 2 lakh has been, it has been approved, and this is the order which has been passed.
Has been approved.
Yes, 22nd,
Give
5,
it to me.
2030.
And when are you going to pay? When are you going to pay?
We have,
Give it to me. The name? Bobita Das. So it has been. So once sanction is given, then he will get the payment. The petitioner has instituted the instant petition claiming the benefits in terms with the notification dated 15/11/2014, notified by the Revenue and Disaster Management Department of the Government of Assam on account of the death of her husband, who died in a road traffic accident on 30/7/2018. The grievance of the petitioner is that the respondent authority, upon being represented, have not taken any steps for payment of the say entitlement to the petitioner, for which the instant writ petition has been filed. This court had issued notice on 10/3/2023. Mr. S. Purva, appearing on behalf of the Deputy Commissioner Golaghat, submitted that that an amount of rupees 2 lakhs have already been sanctioned favoring the petitioner. To be disbursed to the petitioner's bank account bearing number 3047188238, maintained in the SBI Dergaon Dergaon. In that regard, the order dated 22/5/2023 has been placed on record, which is, it has been submitted before this court, which is kept on record and marked with the letter X. So, taking into account that the amount has already been sanctioned and would be disbursed to the petitioner's bank account, nothing further survives in the instant writ petition. It is, however, observed that if the said amount is not received by the petitioner in her bank account within a period of 15 days from today, the petitioner shall produce a certified copy of the instant order before the Deputy Commissioner Golaghat, who shall, upon receipt thereof, disburse the said amount to the petitioner's bank account mentioned in the order dated 22/5/2023 forthwith, and not later than 15 days therefrom. Petition. 20 same? 21. What is the name? Anupam Das is same?
21.
No, this is
21 is Panitan, right?
Malati Tudu is not here, na?
2239.
Huh?
Petition number 2239.
Where is it?
Panitan.
Namgi petition. Huh? Paniji Das, I'm not concerned. Yes, what is this status? We have sanction done.
No, here we haven't got any sanction order, but we have got the Paravais comments, which says that police verification, all those requirement has been meted up. But as regard the sanctioning, no.
Okay, then it will go by the other order by which her name will be put.
Yes.
She submits that similar orders have been passed, and as such, I will direct And the commissioner and secretary to the government of Assam Revenue and Disaster, where he will submit a representation along, submit the instant order, who will pass the order.
Yes, that would.
No similar order is supposed.
So he submitted before deputy commissioner, madam.
No, commissioner and secretary. Revenue department, this is your notification. You take it up with the deputy commissioner. That is, all the orders have been passed to that effect earlier. That has been going on. Huh?
Before the deputy commissioner.
Deputy commission is already gone. The payment has not come because of you.
No, as we received the sanction order from the deputy commissioner, then
Madam, you want to challenge the order, go before the division bench. These type of orders have been passing all along. I'm not going to change it. এইটো সেই তেওঁলোকক সুধিলে এই আমাৰ বিজয় সুধিলে বিল পাছ
18,
The issue in this matter, your lordship, is that there was an order passed by the excise department where, because of restrictions from the locality, petitioner was directed to shift the location of his IMFL off shop, your lord. And during the inquiry, it was also seen that the building from which the shop is currently operating, the NOC given by the GMC is for a residential building, your lord. So they cannot operate a wine shop from a residential building. So if your lordship may kindly have a look at the order of 23rd March 2023.
You have not filed affidavit.
Perhaps an affidavit may not be necessary, your lordship, because a statement was made on behalf of the petitioner that they would produce a document that the NOC is actually for a commercial building. So and after that, adjournments were taken on 26th, 4th, 2nd of May. And
Yes,
5th
Mr.
of-
Counsel. My senior is not there. But then,
Your lordship, it's a matter that regarding the title of the land still pending for.
I'm not concerned whether the permission which has been granted was for commercial purpose or not.
My lord, was for a residential purpose. but
Then how can
front-
you have it? Is it permissible?
But the front side of the building, since it is located in Haskell area. So the front side of the building, commercial purpose, that for order, we will need require some 2 weeks time to get that. That front side, the back side of the building is completely for residential purpose. Don't argue on that. But the front side of the building is located in a Haskell area.
Hmm.
And the area is completely commercial.
That submission they may be bound by the submission that they have made, your lordship. Because
Mr. had submitted the impugn order has been passed on to and man here submitted the premises on the business unit is presently running in an unauthorized for any commercial purpose, and in this regard he has produced before this court a no objection by the Guwahati Municipal granting building permission which is for residential and parking. To raise the issue of the validity of the land agreement. There is no issue. But there is another bit. And the premise for which is running the building is actually for business purpose and no objection from which the business has been done. Mr. Counsel, as of now, you don't have. It is only on the basis of your statement this order was passed.
Since I don't have the book now, as was the matter is pending, the owner of the land, there are 2 owners of the land. We are over. So that regarding the.
I'm only concerned as to whether the land is for commercial or business purpose or not. That is the.
Land is for commercial, residential. purpose.
That-
But the front side of the land. we are talking-
Your submission was the document which was produced by the excise department was wrong because that was for some other building. That was the submission made.
Your Honor, since in the location of the shop, and Lord, there are 2 parts of the building. One is the front side, where my shop is located, and one is the back side of the building, where the residence is made. There are 2 parts of the building.
Show me the excise act where it says, let me dismiss that type of it.
I have otherwise instructions, your lordship,
that if they are, because it's a wine, they have a license is valid. If they are willing to shift, your lordship, the department is willing to grant them 4 weeks time if they want to take.
Hey, no, Assam itself.
So, I mean, if they are willing to shift on their own, department is willing to grant them 4 weeks, perhaps.
No. That is not possible. I also know. Because the moment they want to shift, they have to take the no objection from that area.
From that, wherever they want to shift the entire
That is the biggest problem,
Yes.
isn't it?
Yes.
That I know. But show me that route wherein it says that it has to be only where the building is for residential, commercial.
No, it doesn't say in the excise
Then-
rule, but the GMC will perhaps, the GMC rules will say, your lordship, when a building is meant for residential purposes, it cannot be used for commercial.
For that, GMC will break it.
Yes, but
GMC will seal it.
yes,
But who are you?
I'll just,
GMC is selecting.
lordship will take up.
Excise.
For
Pressurizing.
that, the
No, I'll-
GMC will do it, not you. Just for example, let us go
Huh?
to the GNB road.
290.
This GNB road, there are so many shops out there where the shops are on the, what we call, on left or right. There might be some residential building also.
No, your lordship, there is a rule. I'll just take your lordship.
Okay, we'll have it on some other day.
Lordship, may I have it at 2 o'clock? I'll.
We'll have it at 2 o'clock.
Amendment A. Yes. 294A, subrule 2A.
Two?
Subrule 2A, your lordship, that the Gaon Panchayat municipality or town committee stroke municipal corporation concerned in whose area the premises license for wholesale or retail when is proposed to be shifted has given no objection to that.
This is for shifting.
They started with a shifting process.
And
They shifted their shop to this.
and we have this certificate.
They
As-
shift.
As, that is at page 44.
It is subject to the fulfillment of it. The municipal corporation had given a certificate.
Yes, then when we,
And even the circle officer has given a report saying that it is a commercial plot. Because that.
No,
is from-
understood. Okay, now if the municipal corporation has given the no objection, unless that no objection is not cancelled by the municipal
Yes.
operation,
so,
corporation, what business you have?
we received objections, your lordship. We received objections from people residing within a 75-meter radius of the shop, your lordship. So we are duty bound to consider their objections. Their primary ground of objection was that this is the NOC which has been granted is in a residential building. So we asked for a clarification from the GMC. In the response, your lordship, is at page number 61, where they say that the NOC is for a building and the building is for building, the owner is somebody else and the building is a residential building.
But in respect of that, there is again a civil suit pending. In regard to the title and all those civil suit is pending. And in regard to the budget objection, when I look.
They did not cancel the no objection.
Yep, no, they didn't no objection per se, your lordship, is not the difficulty here. The difficulty is that people residing within 75 meters of their area, they have raised an objection that you are allowing a shop to run in a residential building.
Where is that communication by which you have rejected?
The
Yeah, you have-
communication, the order is at page number 68, your lordship.
Your Lord, will see clause number 1. There is a clear objection from the residents of the neighborhood in terms of Route 289 and 295 of the Assam Excise Code. 24 persons were examined 18 are for and against is 6. And so far 1 is concerned. That is reflected in page number 59. So far first is concerned.
So this is not done under 294A,
This,
this order?
this 294A is for only, it prescribes the restrictions which are to be imposed while application for shifting is to be considered.
Then? Now tell me whether these people,
Lordship,
who are the people who have objected?
they are before your lordship.
Who are you?
I appear for respondent number 6, Lordship.
Who are you?
I am Khattigaon Sammilita Mahila Parishad.
Who are you for the purpose for this objecting?
I reside within that 75 meters.
Fantastic. So you are not in that building?
Beyond 75.
No. You are not in that building. Now, whether there is any other wine shop in the locality?
No, no,
There's no wine shop in your locality?
no.
Well, there is a wine shop. My friend is not aware. The problem is all page 72. Here number 25.
Number 25. Khattigaon.
Same road.
Is it not in your locality?
Not within that 75 plot, 75 meters plot.
Look, they are not even within the 75 meters vicinity of the wine shop. The complaint can be entertained only of people who are within 75 meters of that vicinity.
In this case, Lordship, it's within that 75 meters. In this case, it's within that 75 meters plot.
Respondent number 6, where is your office?
I have given a paragraph number 21 of section at page 90.
No, let me ask him, Mr. Babu. Mr. Kumar, don't be overexcited. Take a seat. Yes. Where is your office?
Lordship,
You are representing somebody. You must be knowing it.
Lordship, the address is that which was stated in the cause list, Lordship,
Huh?
cause title, Lordship.
Where is your office?
That-
You must be having some registration or something.
Yes, Lordship. That at this moment it's represented by the president only, Lordship, and
Huh?
Lordship, it's within that area, Lord.
You can't say within that area. Somebody's right of livelihood is being taken away on your basis. The law categorically says 75 meters. So within this 75 meters, do you have your office?
Lordship, may kindly peruse page 47, Lordship.
Page 47.
The heading, Lordship,
Yes.
Vishnujyoti Path, Hattigaon, Kamrup, Mahanagar, Guwahati, Assam.
Vishnu Jyoti Path, Hattigaon. Where is it?
That's
How far is it the distance from Vishnu Jyoti Path to his shop?
700 to 800.
Then? That is why now they are harping on another aspect, commercial.
Lordship, otherwise, Lordship, at page 51, Lordship will find, Lordship,
Page
51. They have signed, Lordship, and those are the residents of that area, Lordship.
what is this?
Lordship, the translated copy is at page 49, Lordship.
There are members of that area lordship residing.
Then what is the problem?
They are members of that Mohila Samiti lordship and they are residing within that area lordship, 75 meters.
So why have they not approached the authorities themselves?
They lordship approached to this Mohila Samiti jointly lordship. So, the
Somebody
reason of-
being a member today of your Mohilas committee may also object out there, nobody also. Huh?
Maybe lordship, but then it's a valid.
What is this?
Lordship.
Hattigaon.
They are disturbed by this lordship, so they
No, first of all, have you objected to the other shop? Tell me, have you objected to the other shop?
that instruction at this moment I don't have.
And when did you object? After he got his license?
Lordship.
And excise department has also conducted an inquiry, your lordship, find that thing is 59. After the complaint. Yes, page 59, second paragraph, last 59. During inquiry, the total numbers of neighbors within the 75 villages were found to be 24, and among them 6 neighbors have objected in allowing to establish the ample of the.
Where?
Page 59, the second paragraph, that Madam Hattigaon, your lordship will look at the last.
In their
59.
complaint, has expressed their concern regarding disturbance of peace and tranquility in the locality where off license is being proposed, and in this regard, the undersigned along with so and so visited the site where the number of mentioned rented also realized. Of demand regarding the establishment of area would create for the neighbors within 25 meters from the proposed rented. More than 6 neighbors have objected to allow the of mentioned site. Yes, 6 neighbors have objection. Then
24 has favored for opening of the shop. Well, because all these are put up by the other shop in the Hattigaon area, so that in another shop doesn't open up in this area. Because in.
you file your affidavit showing a bona fides.
Lordship, after only the shifting was allowed, lordship, that objections came to be raised.
Mr. MP Sharma appearing on behalf of the respondent number 6, as well as Mr. KP Pathak appearing on behalf of the excise department, is directed to file the is given the liberty to file their affidavits in the matter. Affidavit in opposition is given the liberty within a period of 4 weeks from today. List the matter again on September 8th, 2023. Interim order passed earlier shall continue, please.
Lordship, in the meantime, since the categorical statement was made by the petitioner that the NOC that we had referred to, since the categorical statement was made by the petitioner that the NOC which we had referred to is in respect to another building, and they were going to produce the other NOC, let them produce it, Your Lordship, because that was the sole basis on which the interim order was allowed, Your Lordship. Because that is reflected, just for 1 minute, if I may take your lordship to the order, Your Lordship. Let them at least produce that certificate. It will allow us to get to the bottom of the matter, Your Lordship. Because if indeed it is for another building, it will help us also, Your Lordship, in resolving the issue.
Invisible hand is pulling him to my your lordship.
No, that-
Reply.
that-
If it is in opposition, we'll file our reply.
No, but it is already there in the order, Your Lordship. I am not saying anything new.
File our reply.
It is there reflected in the order dated 23rd March.
I've told the bona fide of the person.
So let them produce the document.
We'll produce all after you file your statement.
You file your affidavit, we'll look into it. Because I don't see any bona fides on their part.
No, on
You
not,
were all along, no. I can make a very well an observation out here as regards what you are saying about this thing, because it doesn't show unless the GMC cancels that certificate. There's no business out there you to say anything to the as regards the commercial and non-commercial aspect of the matter.
no, not on, if the objection, Your Lordship, to determine if the objection is bona fide or not. Because if the objection might very well be not be bona fide, Your Lordship. To determine if the objection is bona fide or not, we at least have to have the documents in front of us. If the petitioner, what the petitioner is saying is true, that the document that they have produced by from. that
Mr. Pathak, kindly satisfy this board that a commercial building on whether it is that you require that the building permission has to be commercial as per the Excise Act. Show me that.
The rules are cited.
No. Show me that. If it is not there, if the rules and the act does not say so,
Lordship,
come up with an executive instruction, then we'll look into the matter.
very well. Obliged.
Yes.
Elected president, my lord. Elected president, my lord.
Hmm.
Position has been brought by the sixth member of the president directly to the queue of the Anchalik Panchayat, violating the mandate of.
Where is that other person? Panchayat PNRD?
Page number 29.
Where is the PNRD? Copy of the requisition dated demand, copy of the representation of the demand.
President of the section.
Have you been thrown out?
My lordship,
Have you been removed?
my lordship, and forwarding has been sent to the deputy commissioner to my removal, my lordship.
By the secretary?
By the Anchalik chairman, page number 29. itself. Executive officer, the Anchalik.
You are the president of the Anchalik Panchayat.
I am the president, my lord, local chair.
Okay, so the GP has to send it to the Anchalik Panchayat.
My lord, right, correct. my lordship.
Then?
In this case, my lordship, kindly see the requisition at page number 20, my lordship, where the requisition has been directly sent to the CEO of the Anchalik Panchayat, my lord, clearly violating the mandate of section 15, my lordship, and 52 of the Panchayat Act, my lord. At page number 20.
No confidence when with respect to the, we understand to 15. We have no GP secretary and informed that. Time. Then what has happened thereafter?
My lordship, after this position at page number 20, my lordship, I came to this, my lordship, to some friends, my lordship, then I have sent it to some common friends, I come to know about it. It has been directly given to CEO of the Anchalik Panchayat, my lordship,
Hmm.
without giving it to the secretary or direct to the president. Then
Is
my
there a
lordship-
secretary?
my lordship,
Is there a secretary of that Gram Panchayat?
my lordship is there, my lord. Yes,
Or they are saying there is no secretary?
yes, my lord, there is a secretary, my lord.
Okay,
Then
then,
when I come to know about this incident about on 26/6, my lord, at page number 23.
Hmm.
My lord, I have sent a memorandum to the GP secretary
when did you come to know?
on 26, sir, my lord.
To the GP secretary?
My lord, GP secretary, my lord.
Okay, then,
Then my lordship, on that day itself, my lordship, the Anchalik Panchayat president, my lordship, has passed the no confidence motion against me, my lordship.
who are you?
My lordship, I am the president,
Who has passed the AI against you? Anchalik Panchayat?
Anchalik Panchayat, my lord.
No confidence?
No confidence. By the 9 members, my lord. This case, my lord, they have completely violating the guidelines of.
So you want a stay of 1626/6?
Yes,
Yes, madam.
Let's see, we have received the copies just now. So,
I am only on the point of law. Is it possible to do like this? Can somebody write to the Anchalik Panchayat? The member? When rule 15 categorically says that they will be, it is the GP who, the secretary who has to write to the Panchayat, isn't it? The Panchayat Act shall be specifically convened by the secretary of the counter with the approval of Imam. Such meetings shall be presided over by the president. If will- Shall be deemed to have vacated his office when a resolution. is written. So, rule 15 says if there is no GP secretary also, these people should have represented to the president. And then the president, if he does not do, then they could have
Then they-
proceeded to the,
Anchalik Panchayat, then Anchalik.
at all the president is not there, the secretary is not there. But here they have directly approached the Anchalik Panchayat. This is not permissible. Issue notice making it returnable on how much time, madam? Okay. Issue notice making it returnable on 25th of August 2023. So appears on behalf of the respondent number 1, 2, 4, 5,
7, 8,
7,
and
8, 7, 8.
7.
Mr. S. Borua appears on behalf of the respondent number 3. Baki kita jun kita nase. As the respondent numbers 1, 2, 3, 4, 5, 7, and 8 are duly represented by the learned councils, extra copies of the requisition be served upon them during the course of the day. As regards the respondent numbers 6, 9, 10, 11, 12, 13, 14, 15, 16, 17, the petitioner shall take steps by way of registered as well as usual by 31st of July 2023. The case of the petitioner herein is that the petitioner is the president of Rangirghat Gaon Panchayat under Sonai Anchalik Panchayat. Six members of the said panchayat, instead of approaching the secretary of the said Gaon Panchayat or even the president, have directly approached the executive officer, Sonai Anchalik Panchayat and Development Block, Achar, expressing no confidence under section 15(1) of the Assam Panchayat Act 1994 against the petition. Have approached the executive officer Sonai Anchalik Panchayat and Development Block on 9/6/2022. The petitioner, on coming to learn about the same, the petitioner came to learn that on the basis of the said requisition, the president of Sonai Anchalik Panchayat took steps for convening a special meeting of the Gaon Panchayat in question. Immediately thereupon, the petitioner on 26/6/2023 issued a communication to the Gaon Panchayat secretary of the said Gaon Panchayat, to the secretary of the said Gaon Panchayat. However, on the same day, that is on 26/6/2023, the special meeting was convened, and the said no confidence motion was passed. This very aspect of the matter was brought to the attention of to the Deputy Commissioner by the Executive Officer Sonai Anchalik Panchayat via another communication on 26/6/2023. It is the case of the petitioner that the Assam Panchayat Act 1994 and more particularly section 15 mandates a manner and procedure for holding the no confidence motion against the president or the vice president. The learned counsel appearing on behalf of the petitioner further submits that the mandate of section 15 having not been followed, which is mandatory in nature, the resolution so adopted on 26/6/2023, as well as the communication dated 26/6/2023 issued by the Executive Officer Sonai Anchalik Panchayat, is on the face of it illegal and liable to be interfered with. I have perused the materials on record and have also taken note of the contentions so made by the counsels appearing before this court. From the documents on record, it is seen that the 6 members of the Gaon Panchayat in Cochin have, without approaching the secretary of the said Gaon Panchayat or even the president of the Gaon Panchayat, have directly approached the executive officer of the Sonai Anchalik Panchayat, which is contrary to the provisions of section 15 of the Assam Panchayat Act 1994. Taking into account the infraction to the said provision, this court is of the opinion that this court states the resolution dated 26/6/2023 held in the special meeting of 14 number Ranirghat Gaon Panchayat, as well as the communication dated 26/6/2023 issued by the Executive Officer Sonai Anchalik Panchayat to the Deputy Commissioner Kachar till the next date. It is, however, made clear that if the resolution dated 26/6/2023 as well as the communication dated 26/6/2023 so impugned in the instant proceedings have already been acted upon, inasmuch as the instant writ petition has been filed almost after one month. The interim order passed herein above shall not be applicable. It has not been acted upon. Have you been removed?
19,
Will not be applicable litigation. The interim order passed shall not be applicable. Yes,
This case of the food health department, designated officer to the third director of this. Not to act on my complaint.
yes. Whether there has been, yes, you were supposed to say on that date.
Like it has been acted upon.
You have acted upon.
Yes.
So nothing remains in the writ petition.
I don't know how.
The last page, Lordship will find the opinion.
When was this?
This is of my lord,
There was a direction given on
29/10/2022. The designated of,
19/9/2022.
yes,
And your, this particular report is of 29/10.
29/10.
And what else was your prayer, Mr. Majumdar?
Lordship, if there is a take necessary action against the manufacturer if they have violated the
That
provision of the act.
they will put for hiding it. Analysis report is already there. You filed something out there, I remember.
Then I.
So that has already been made public because you filed objection against that, if I'm not wrong.
Initially, this analysis report was put to the cold storage for a long period.
But now it has been made public. So number 2 is gone. Number 4 is respondent number 4 to take necessary action against the manufacturer of contaminated packaged drinking water. So that is it. Now they had made the inspection on 29/10/2022 and found that the sample of the packaged drinking water Bisleri conforms to the prescribed standard as laid down by so and so. So this is what has been given. What remains? Nothing remains.
Yes, but the issue is that
I think better, why don't you move the, if you have any problem, why don't you move the consumer?
My lord, that will be more appropriate.
You want something, you prove that something. Wouldn't that be difficult? How can this court under writ jurisdiction do anything?
they
Okay.
are, I can submit back the, but authority are responsible to take the act. That is for a penal. Yes.
Whether there is a penal provision or not, the first is the adjudication of facts that the penal provision would be applicable. Isn't it?
Yes.
So you have to prove it. Prove it. You file a criminal complaint. There is a, I think you can file a criminal complaint.
Against the violation.
Yeah. Against, file against Mr. P.K. Dekar.
Authority. I, one, I may be allowed. By. If I get the.
Yes,
copy of the report.
Okay. Mr. D. Gogoi appearing on behalf of the Health Department have produced the report of analysis so made by the food analysis to the government of Assam. On 29/10/2022, in compliance with the order dated 19/9/2022 issued by the Food Safety Officer HQ Karimganj. The said analysis report in the said analysis report, it is opined that the packaged drinking water bracket brand Bisleri bracket close conforms to the prescribed standards as laid down in regulation 2.10.8 of the Food Safety and Standards bracket food products standards and additives bracket close regulation 2011 with respect to the test carried out and the provisions of food safety and standards bracket labeling and display bracket close regulation 2020. The same is kept on record and marked with the letter code gold pen 9. Marked with the letter X. Mr. FZ Majumdar, appearing on behalf of the petitioner, submits that he may be given a copy of the said analysis report so that he can obtain necessary instructions from his client as regards the future course of action. List the matter after 4 weeks. But Mr. Majumdar, I think you should file a consumer. This repetition won't. In fact, this is, you will be doing something good for the society also, filing a consumer or what do you call? Criminal complaint.
My client is also affected by
You should file this, then only something will happen. Because now this court can't do anything on this aspect. And delay may affect your right in the consumer forum. Yes.
20,
Yes. Non-payment
That admissibility report, my lordship will give me 7 days time. I will have time.
for what?
That the admissibility report.
Page?
13 and 14.
The amount is 3 lakhs. Oh, yeah. Okay.
Was contacted by
Physical verification of SDR. 3 lakh.
then by the next page.
Then? Work done.
My lord, serial number 9, my lord. Was executed as per then and executed.
This is given by the circle officer. Who is to make payment?
By the deputy commissioner, my lord, not by PWD.
Huh?
No, no,
Who is
Not
going to
by-
pay?
no.
What are positive by the executive engineer, my lord?
Restoration of Mohandam West Road under SDRF. What is SDRF? State Disaster Relief Fund. So it will be given by the Deputy Commissioner,
Yes. Yes.
isn't it? Isn't it? The Deputy Commissioner have done all this
Yes, my lord,
verification.
yes. In fact, my lord, as per instruction, my lord, the respondent number 4 has stated that, my lord, it is not the responsibility of the PWD to make the payment.
So it will, Deputy
Yes,
Commissioner.
sir.
What?
We have only implemented the, my lord.
Okay, Deputy Commissioner, you verify, make payment within 6 months from the
In
date
fact,
of
here,
certificate.
DC is not a party. Not a party. DC is not a party in the return.
Ah, Mr. Council, what to do? You know or you are relying upon the major documents of the circle officer as well as the Deputy Commissioner. Then why you are not making him a party? I can't help you with this. You are making unnecessary finance. What does the finance have to do? Public Works Department.
Sometimes the finance is made part.
It's okay, but why you are making unnecessary? Tamsir Ali will cause more hurdle to you. What to do? Everywhere the Deputy Commissioner you have been mentioning and you are not making the Deputy Commissioner party. And in fact, these type of matters, that day I've allowed all the matters. But I can't help you with this. What to do? Withdraw and file a fresh one. That is the only way out. Unnecessarily making the PWD a party.
Sir, if it is also direct
So he's not party.
No, whom should I dispose of?
He is not before.
I can't make the deputy commissioner. Your entire thing will change now. You have to approach the deputy commissioner. Have you approached them?
No.
You have not. You file a representation before the deputy commissioner, I give you the liberty, and within some time, if it is not done, you come and approach this court.
Lord.
It appears from the it appears from the perusal of the petition that the work in question related to restoration of modern Mohon bracket West Road under SDRF for 2018. That's 19 under Karimganj Rural Road Division. You entered into an agreement with whom?
They do not have-
Huh? You don't have. It further appears that the petitioner claims to have completed the said work and the additional deputy commissioner Karimganj had directed the assistant commissioner Karimganj to inspect the said work and submit physical verification report along with photographs. Subsequent thereto, the circle officer have given a report that the work had been executed by the petitioner as per the approved plan and estimate. The petitioner herein claims the said amount, claims an amount of rupees 2,49,331, which the petitioner, which the respondent, which the authorities concerned have not paid. Mr. B. Gugoi, appearing on behalf of the PWD department, submits on instructions.
Reflect this order, my lord. It is the Revenue and Disaster Management Department who is the main government.
That
including
it is not the PWD who is required to make payment. Rather, it is only the responsibility is on the
clause number 1 and 2, my lord.
responsibility is of the Revenue and Disaster Management Department. And the payments to be made to the would be made subject to entitlement by the deputy commissioner. However, it appears that the deputy commissioner is not a party. However, it appears that neither the Revenue and Disaster Management Department is not a party to the incident proceedings, nor the Deputy Commissioner Karimganj is a party to the incident proceedings. Taking into account the above, this court therefore disposes of the incident with petition, thereby permitting the petitioner to approach the Deputy Commissioner Karimganj by filing a representation claiming the amount. Full stop.
Twenty-two.
Now, therefore, in that view of the matter, no effective directions can be passed in the instant writ petition against the respondents. The petitioner is well advised to approach the Deputy Commissioner, Karimganj, for redressal of his grievances. Itu aku like to know.
22.
Same. Oh. Tell me. What is this?
Aadhaar card.
Non-issuance of Aadhaar card to the petitioner without assigning any reason in spite of her repeated enrollment under the so and so. Huh?
Here, the technical, you may say, because the biometrics of the petitioner has been taken during the process of NRC updation, and that process is being stalled because of the Supreme Court proceeding. And so government have issued a SOP to that effect that the persons who biometrics has been taken in the NRC process will be kept on hold. So accordingly, some of such petitioners.
He wants
have
an
received-
Aadhaar.
Yes, that Aadhaar.
Ah.
That's what the Aadhaar is related to, that biometrics which has been taken during the NRC process. The persons who haven't got it, and that has been kept on hold. There is an SOP issued by the Home Department.
For what? Means
Because
somebody's NRC is
Yes.
not issued.
Yes.
Then he's not going to get Aadhaar.
that's what.
Show me that.
Yes,
The very serious thing.
yes.
On the other hand, you want the Aadhaar to be linked with your bank account. You want the Aadhaar to be linked with many other things,
Yes,
and
it-
you are not issuing
It is
this.
with regard to only those persons whose biometric has been taken during the
With
NRC.
regard
process.
to the Iman, I'm directed to inform you that Aadhaar card of those applicants whose biometrics by collected evening claims and protection status are still kept on hold as per the SOP approved by the Supreme Court. The matter is pending with the Supreme Court. The same. How is this relevant?
In fact, that is not with regard to petitioner. It is similar similar person has been communicated in that way. But I have received that communication and also the Paravis comments.
No, no.
This
Mr.
is what
Counsel,
the right.
you see, if he doesn't have the Aadhaar, he has a lot of problems.
That's true.
You also have your Aadhaar.
I have.
You also have your biometrics was taken in the NRC.
Yes.
Why the petitioner NRC was given then not
Because-
taken?
Maybe in the intervening period when the NRC entire process got stalled because of the Supreme Court proceeding.
But now also a person can very well go there and get
But
his NR.
That's the instruction, because some SOP has been issued from the Home Department. Not
You don't have the SOP brought here.
that SOP has been referred to, but I
No,
haven't
no,
got.
you have not. Well, Mr. S. Bolu appearing on behalf of the respondents refers to
You know,
refers to a communication issued by the Deputy Secretary to the Government of Assam Political B Department, wherein it has been informed that Aadhaar card of those applicants whose biometrics were collected during the NRC claims and objection stages are still kept on hold as per the SOP approved by the Supreme Court of India. The learned counsel, the counsel, Mr. S. Bolwa is directed to produce the SOP on the basis of which the said communication is issued, and as to whether the said position still holds good taking into account that the said circular so mentioned is almost a year back. List the matter again on
I please, Your Honor.
21st of August.
I'm appearing on behalf of Mr. B. Dekar, learned CGC. For respond number 1234. We need time to file our affidavit.
You want to file your affidavit in the meantime. I'm not going to say.
Deeply object.
Supplemental is item 40.
But Mr. Borwa, this has very serious consequences. I don't think the SOP, the Supreme Court must have stated this in this manner. It couldn't have been. On one hand, everything is being approved. You can't do anything with without an Aadhaar. Merely because your claims and objections were there in the NRC where you have submitted your papers. How can you do
But
that?
here it refers to a particular class of people whose entire process got stalled. So that's what has been.
That is for the purpose of NRC.
NRC.
Somebody's NRC has been kept on hold. The NRC proceedings are still pending in the Supreme Court. That is another aspect. But for that not to give the Aadhaar card,
Maybe the biometric is not. taken
maybe
twice.
somebody has been rejected. That might be the
That might be the
reason.
reason,
That
yes.
is another thing. For whom Aadhaar card be gone. But otherwise the petitioner's life, everything is affected. Yes, who is appearing?
Item 40.
40 minutes, I have received the instruction due to some excess payment, my lord, that has been involved and arbitration proceeding is going on, my lord. That's why that amount has, that is the instruction, my lord, I have received.
Okay, none appears, na? You,
Yes.
Ms. A. Gayan appearing on behalf of the respondents submits that she has received the instruction and will file an affidavit in the matter. List the matter after 4 weeks. In the meantime, the affidavit be filed.
42.
Yes, affidavit filed.
No, in fact, no, the question of affidavit, in fact, last occasion I have
Oh,
made a
this
submission.
matter.
Yes, I have made a submission that the instructions are there, but those instruction happens to be a old one. So accordingly, I have made a verification to the office. So they have come up with a new instruction, set of instruction. And from going to that particular instruction that I have been provided, I can make out that the particular day on which order from this court has been granted to this the previous order was of 7/12/2022. Deputy Director, Food and Civil Supply, Consumer Affairs, to restore the status quo ante. So these has been granted, and after that again the matter has been, set of matters has been taken up by the High Court on 22/12/2022. These matters were accordingly been rejected, dismissed. So
which matter?
On that basis, yes. So this is, but
Oh,
here,
that is
here it is
different.
the same.
No.
It is
Here is the case that she had 51.
She had 51, not on the base date.
Not only on the question of base date, she had 51. You see, that is a matter where there was a particular manner in which everything was done. It was found that anybody having less than
Less than
50
50 were tagged.
tagged.
Yes.
Now here is the case, here she had 51. You remove this 51 and as such there is a status quo ante order.
No.
And when the status quo ante order is passed, then why haven't you complied with it? Have you restored the 51? No, Mr. Borwa, I am asking you.
Yes.
Have you restored the 51 to them?
No, that hasn't been done.
If
because
you have not
after-
done, then you have submitted, who has appeared for this? Who is supposed to do this? We'll call that person, that is director of Food Civil.
In fact, if your lordship goes to this, what I can make out, or if at all-
No. I am not going to look into it. There is an order being passed on 7/12/2022. On that very date, there was a direction for passing an order of status quo ante.
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 Yes.
Status quo ante means on the date, it will go back on the date on which she had 51.
So here again, if I have to get hold of the judgment of the 2022, if I have to be clear about what I am submitting here. So that order says that note that some cases the license authority have renewed the license of the petitioner. Such renewal is contrary to the policy decision of the government. As such, the renewal so granted would not confer any right upon. Here, the petitioner also claims that she has been renewed. But again, it will be contrary to what the High Court has said. So I have to get hold with this judgment. in-
Mr. Borua, that judgment I have given.
Yes.
I remember.
Yes.
That was the contention of the petitioners out here is that they were having somewhere having 25, 30 also.
Yes.
Then also there was a renewal given. And in spite of the renewal, then therefore they said as the renewal has been given, they had a legitimate expectation that it will continue. This court held that when the policy decision has been approved out there, nothing comes out there that 25 or yeah. But here is the case is different. Here the
She
case
has
is
more
she
than
had
50.
51
Yes.
and you have removed the.
So, Lordship, my humble prayer. In fact, my
We
previous.
asked the director of civil
No,
supply.
Lordship,
to
before
be
that, may I
present. No. There is a direction passed by this court on 7/12/2022.
Yes.
And you have not done that.
That has been communicated, but
No,
maybe they must have mistaken that entire communication because unless and until they mistake it. they
Madam,
wouldn't
you have
come up with
submitted
this.
the certified copy to somebody? Whom? Okay.
Lordship, may I come up with a,
No.
I have to be making them clear.
No, I have not. You have
This
not even
instruction
filed the
has come
affidavit.
subsequently, Lordship.
No, you have not filed the affidavit. You say
No,
that
that
for the
affidavit,
respondent that he has received that
Lordship-
and he would like to file a.
No,
Taking
Lordship,
into account that the
Lordship,
order
I have to
that
be
were
clear about
passed
it.
by this court have not been implemented. This court grants 1 week's time to the state
Yes,
accordingly.
that is my submission. I say because that Paravai's comment was dated 29th of December
Lekho.
2022.
Lekho.
Lordship,
No,
2022.
we asked him,
This is with
I
regard
am
to 2022.
keeping up the matter again on 7th of August, on which date the deputy director shall appear as to why contempt proceedings should not be
Lordship,
initiated.
I will file the affidavit. I
Then
will
file
file
it
that.
by Monday.
Yes. No, Tuesday. Lordship.
Monday. You file it by Monday. That's all.
Yes.
And it has to
With
be
regard
filed.
to, with regard to the 7/12/2022 compliance.
Yes.
That has to be.
No,
brought into
whatever
record.
you have to say, entire thing be brought on record. On that, your stand has to be brought on record
Yes.
by Monday. I mean, fixing it on. I'm fixing it on 7th. You file the affidavit by 4th.
Yes.
List the matter. Now, full stop. This court had specifically directed the respondent authorities to file their affidavit by an order dated 17/7/2023. But no such affidavit has been filed. It is further from the submissions of Mr. S. Borua, the learned counsel for the state, it further transpires that the order dated 7/12/2022 passed by this court, passed by this court, thereby directing restoration of status quo ante have also not been complied with. In the said affidavit, the concerned respondents shall also explain as to why the order dated 7/12/2022 has not yet been complied with. List the matter on 7th of August 2023. The affidavit be filed by the state respondents on by 4th of August 2023 by serving an advance copy to the counsel appearing for the petitioner. It is made clear that if the affidavit is not filed as directed above, the Director of Foods Civil Supplies and Consumer Affairs, Assam, shall be personally present in the court at 10:15 on 7/8/2022. Agita,
I know 23 orders.
एक बार लिस्ट कौन बनवा लेंगे? Yes, none appears. So this person will come.
23.
Yes,
23 lordship, along with, item number 29, 30 and 32 lordship. In, item number 29, I have received one instruction lordship. Higher authorities out of station lordship, so we need some time to take decision lordship. Kindly produce my instruction lordship regarding the fund lordship. Question. 23, 29, 30 and 32. 32. 30 and 32.
madam, we fix the matter again on next week, on
Lordship,
7th.
they seek for
On
2
7, nothing doing.
weeks type lordship.
2 weeks is 7, no. That person, these persons are not there on 28 till 28/7 till today. We are asking you to obtain instruction as to when the funds would be available. Get your funds available by 7th. Item kungita gole?
22, 23, 29, 30 and no,
Huh?
no, more. 30 and 32.
30 and 32. Gutikitat likhi diba? Miss, the learned counsel appearing on behalf of the respondent contemner submits an instruction issued by the Secretary, Boroland Territorial Council, wherein a request have been made to seek 2 weeks' time so that the decision of the BTC authority could be obtained. To list the matter again on 14th of August 2023, on which date the learned counsel appearing on behalf of the respondent contemners shall apprise this court as to when the funds would be available for payment of the same to the petitioners. Same.
And lordship, in case, another thing I want to add, lordship,
23,
in Lanipa Sokya,
29,
item number,
You are mentioning, Madam Bora, you are saying 23, 29, 30 and 32, na?
yes, lordship. In
Okay.
32, lordship, another thing has been stated, lordship. Audit has been done by the NITCO, lordship, regarding the contract matter, lordship. It is for another thing in item number,
32.
yes, lordship. Lanima Sikha.
Thirty-two to eta kotha koi likhibo. The learned 32 to belek ke likhibo. I agor to likhibo 29, 23, 29 and 30 same or 32 to likhibo. Mrs. Bora, RB Bora, Learned Counsel appearing on behalf of the respondent contemner submits that the audit report in respect to the scheme under which the petitioner has claimed the amount of rupees 54,57,587 is yet to be received from MS Nitcon, all caps, NITCON. And under such circumstances, no steps could be taken without the said audit report. It is the opinion of this court that the said aspect be brought on record by way of an affidavit. List the matter again on 14th of August 2023, by which date the respondent contemner shall file an affidavit without fail. It is made clear that if no affidavit is filed, the respondent contemner shall be personally present in the court.
24.
Madam, why don't you file a short affidavit? Just in some other cases I could see. You say that this person, Anurag Goyal or Kashyap or whatever his name is, he is not there. You say that yes, he is not there, but earlier to that he had taken up, he has received it. That's all. I can finish up this contempt, then otherwise the petitioner has to implead somebody else on. If he does not, then the matter has to end. Why you are not doing that? The simple thing that now this habit of saying that that person has got transferred, that can't solve the problem. That affidavit has to be filed. Yes, next 24.
24.
Yes.
Yes, sir.
Complied?
Yes, sir.
The instant contempt proceedings have been initiated for non-compliance with the order dated 26/10/2021 passed by this court in WPC number 782/2021. It has been submitted by the counsels appearing on behalf of the parties that the said order has been duly complied with. Taking into account the above, the instant contempt proceedings stands closed.
25.
Yes.
Actually, the money has been already paid to the petitioner.
Hmm?
Money has already been paid.
Paid.
As per my information, from my bank, they have received 1 lakh.
Huh?
They have received 1 lakh. from the respondent. But
What is the direction?
2 lakhs. At this 10 years.
Lordship, here,
Oh.
only the principal secretary is made a party, your lordship, and the money is disbursed by the DC, your lordship.
Now, why have you
It's
paid
not
only
made
1 lakh?
party.
Now, why have you paid only 1 lakh?
No, your lordship, we had already asked the deputy commissioner to give the proposal regarding the sanction of the ex gratia to the NOK. Whatever they have given to us, accordingly the payment was made. There must be some anomaly in the DC office, your lordship. DC is not made a party in this contempt petition.
Not necessary. You take it up. The learned counsel appearing on behalf of the respondent contemner submits that out of the direction to pay 2 lakhs, out of the direction to pay 2 lakhs upon verification, only an amount of rupees 1 lakh has been paid. The counsel appearing on behalf of the respondent contemner further submits that the office of the commissioner, the commissioner and secretary to the government of Assam Revenue (disaster relief and rehabilitation branch disaster and management department) have already sanctioned for the payment of the amount of rupees 2 lakhs. However, it is the fault of the deputy commissioner. Which one? Deputy commissioner what?
Kamrup Metro.
Kamrup Metro, not to Kamrup Metro or Baska? Kamrup Metro,
Metro.
not to pay the remaining 1 lakh to the petitioner. This court fixes this matter again on 14th of August 2023, on which date the counsel appearing on behalf of the respondent counsel, a respondent contemner, shall apprise this court as to whether the entire amount has been disbursed by the respondent, disbursed to the petitioner by the officials of the Revenue Department.
26,
Lordship, in this item, your Lordship, the affidavit has been filed and also the money has sanctioned 2 lakh
Huh?
rupees. As directed, your Lordship, the affidavit has been filed on 25th. Also, your Lordship, the money has fully paid.
You got the money?
Yes, your Lordship.
What the money, but information like that, we will directly today for 40.
Lordship, may kindly peruse that page.
It is given here. Amount has been paid.
I think
2 lakh.
but yeah, information that will be.
Friend. The instant contempt proceedings have been initiated for non-compliance to the order dated 21/4/2022, passed in WPC number 4554/2020. It appears from the records that an affidavit has been filed by the contemner, by the respondent, stating inter alia that the amount has already been sanctioned.
No, your Lordship, in the affidavit, the reasons were given why the payment was delayed. Today, the documents which I have furnished, your Lordship, it's given that the money has.
Has been filed by, has filed an affidavit. The respondent contemner has filed an affidavit. Today, the learned counsel appearing on behalf of the respondent contemner has produced a communication issued by the Joint Secretary to the Government of Assam Revenue and Disaster Management Department, dated 26/7/2023. And it is seen therefrom that the amount of rupees 2 lakh have already been released to the DDO Punitpur, Tezpur, for making payment of the ex gratia grant to the next of kin in terms with the order dated order passed by this court. Taking into account the above, the instant contempt proceedings stands closed on account of the compliance. The instructions to produce is kept on record and marked with the letter X.
Pleasure.
27,
Yes, Mr. Naik,
Lordship, in this case, Lordship, I have filed my affidavit, Lordship.
you filed?
My affidavit, Lordship.
You filed?
Yes, Lord.
When?
It was filed on Wednesday, Lord, last Wednesday. On Wednesday, Lord.
You filed?
Yes, Lord. Copy.
The Mr. P. Naik, appearing on behalf of the respondent contemner, submits that the affidavit has been filed on 26th of July 2023. However, the said affidavit is not on record. List the matter again on 9th of August 2023. Of the registry shall. Huh? On 4th.
Contempt cases are different matters, Lord. Contempt
No. This is a contempt. Other contempt matters of you. On 4th. Affidavit has been filed. Okay, we'll have it on 4th. On 4th of August 2023. 4th. Yes. 4th of August 2023. Along with the said affidavit.
28,
Affidavit filed.
Yes, Lordship, on 26th.
Affidavit not on record. Huh? Same order date. खाली है तो B चौधरी को था लिखी Affidavit file on 4th of August.
31,
31, yes.
My lord,
When are you releasing it?
my lord, instructions have been received today only, my lord. And may I come in, my lord? Having regard to 31, my lord. It may be stated that the BTC conducted a comprehensive audit against the aforesaid two schemes in persons of
Mr.
the,
Counsel,
my lord,
have you complied or not?
my lord,
Have you complied or not? There's a direction passed by this court. Have you complied or not? I'm asking you.
not complied, my lord. There are some issues, my lord.
No. If there are issues, have you filed an affidavit?
My lord, instructions have been received only today.
You file your affidavit by 7th.
Yes, my lord.
We'll fix it on 9th.
Yes, my lord.
This is the matter on 9th. The affidavit be filed by the, how many contemners? By the respondent, by the respondent contemner? Without fail.
This matter is similar with the 23 item number. Item number 23.
Item number?
14.
40.
14.
14, I have no matter out. Let him file the affidavit by 7th.
Yes, my lord.
33,
Same matter, my lord.
33, same.
No.
Affidavit file? No.
Full file, my lord.
By 7, they will file, we'll fix it on 9th. Yes.
34,
Obliged, my lord.
Yes, service is complete. Service is complete. Leaves the matter for admission after 2 weeks. Yes,
My lord, we'll file the affidavit during the course of the day.
today.
Yes, ma'am.
The council appearing for?
PNID, SCPNID,
The council appearing for the PNRD department, Mr.
U Sharma.
U Sharma submits that the affidavit would be filed during the course of the day today. List the matter for admission after 2 weeks. Huh? Okay, fixed date will be then on 23rd of August. Next.
36,
Obliged, ma'am.
Can it possible matter?
Huh? No. Hey, almost everything is done. You see, here this problem is there in the month of August. So many, that week of 13, 15, and 18 are all closed, no? That week. So we can't pick. Yes, next, 36.
36,
My lord, we have filed the affidavit of the.
Okay. Which one?
36.
Show me that.
Filing today is not on record, but I.
Oh, this one. Vacated, na?
On 18.
I knew it. And the best part was, luckily, I knew it. This, first of all, your repetition on the face of it was not maintainable.
That part, my lord, will satisfy.
You satisfy me now. I give you 10 minutes to satisfy me.
Other day, my lord.
You have taken service by way of the state. Have you filed the affidavit? When? The council appearing on behalf of the petitioner submits that steps have been taken by way of Dusty and the affidavit of service have already been filed. Taking into account the order passed by the Supreme Court on
Very next day.
18/7/2023 in
My lord, that number has rotated.
Number two Bisailo. To answer.
Andhra Pradesh, MHR, but
Then taking into account the order, the recent order passed by the Supreme Court on 18/7/2023.
already indebted. So
Okay, nothing remains.
posted after
It's okay. List the matter after, list the matter after 4 weeks. Thing remains, somebody else will already be.
43,
Eh? Service complete? Okay. Service is complete. On response number 7. Others are represented. Okay. Service complete. List the matter for admission in the 2nd week of August, 3rd week of August.